Hello? Okay, okay. I will start in a few seconds from now. Good afternoon, everyone. Welcome to the Pulse lecture series. We will be discussing this afternoon evidence. Evidence is a very important subject, most especially by reason of the recent amendments, which was made effective on May 1, 2020. So I would discuss to you the various amendments in the rules on evidence, but I would want you to take into consideration the following parameters or guidelines as I move along with my discussions. Number one, I may at every now and then may make reference to US rules, but I don't intend to discuss that lengthily. To the extent that I will say this originated from a US rule, I think that would suffice. Okay. Now, I think there will be sufficient time for you in your regular classes to discuss at length if your professor feels that the US authorities, US laws will have to be discussed. So, and when I refer to US rules, it means either the uniform or federal rules. Number two, discussion will always be put in context. What do I mean? I will not just refer to a provision and say that there was an amendment on one word and then I'll move on to another provision. No, I will endeavor to explain to you the essence of the provision and to some extent if it has an impact on the provision, the word change or the change of a phrase. Okay. Number three, I will highlight the amendments but not replace it with actual reading of the law. While we will discuss all of these amendments, I do not recommend that you will refrain from reading the law. You should read, most especially the students. Because as you read, you will have better insights of the provisions of the law. Number four, have an open mind. And I'm addressing this to the students. Have an open mind because sometimes concepts can be very complex and complicated. I recall when I was in second year, in law school, about to take up evidence. I had this feeling that the evidence should be complex and complicated. And if it is something that I will be able to understand, maybe there's something wrong with me. But that should not always be the case because the rules are passed to address real life situations. The rules are there to be able to apply to actual problems and controversies. And the next, number five, I hope that this, if there are practitioners listening right now or watching this lecture series on evidence, on remedial law, of course, I hope that this will in some way help the practitioners refresh the things that they still remember when they were students, or those cases that they have been recently handling pertaining to certain provisions of law. I hope that this will assist you in better understanding the provisions of the law. Now, for purposes of time, if you would note the original notice or advertisement for the lecture was for 2 hours, if you would note. Okay? It was for 2 hours. However, kindly take note that I've requested that we may need to extend. So I may need 3 hours. I will give you a break after an hour and a half or an hour and 15 minutes, depending on my progress. I will give you that. And now I would want to like to inform you that every now and then I might be looking at the phone because I am alerted if my connection is not clear. That is the reason that I'm looking at it. That maybe I don't want you to be surprised. I'm no longer there at the screen, and I keep on speaking here, and I'm not aware. I don't want to waste your time. And please, before I start, there is an outline. For those of you who received an advance copy of the outline, that is how I intend to discuss the amendments in evidence. You will see that it will be flipped as I move on. I don't know if students have already a copy at this time. So please be guided with my outline. And finally, should you feel, because I know that there are some people, there are students or even practitioners who feel, I would really want to read what he's discussing. You know, if you are interested, most especially for tomorrow's discussion, I have a discussion in a column at Manila Standard tomorrow on privileged communications. I will discuss that, but I will also discuss it now. In the past issue, I discussed documentary evidence and object evidence. Okay, so in the future, I will also discuss that in writing. Now, let me now start in order to save time. Okay, now, let me start with rule 128. And I always tell my students that this provision, section 3 of rule 128, to me, is the heart of evidence because it speaks of admissibility. Evidence is admissible if it is relevant and not excluded by the law or these rules. That was the original provision. Okay, you know original provision. You look at it. If you have a copy of the 19 of the rules on evidence before this amendment, you will see that. Now, the amendment was the insertion of the word constitution. Yun lang po ang ipinasok. The insertion of the word constitution. But for those of you who have been teaching evidence for the longest time, and those who have studied evidence, you know that we discuss these exclusions under the Constitution. Because when we talk of admissibility, we talk of what? Relevancy, and number two, competency, meaning it is not excluded by the rules. Now, let me call your attention for your guidance of the pertinent provisions of the constitutions that were affected by the insertion. There is Article 3, Section 2, 3, 1, and 2, and Article 12, 1 and 2, and 3, and 17. Now sabihin mo, sir, numero lahat yan. I will give you an idea of what it is. Okay, though the item that is relevant for a particular case, an item is relevant for a particular case, but the manner of its seizure is unauthorized or in violation of the mandate of the Constitution, that there is no probable cause, then it is excluded by the rules. Let us say you were placed under custody of law enforcement officers. You're under custodial investigation. And you made admissions, but the admissions were not made in writing and you were not assisted by counsel. While your admission or confession is relevant, it is what? Excluded by the rules because it's excluded by the Constitution as provided now. Another example would be no person could be compelled to be a witness against himself. While the testimony of the accused may be relevant. Now, my last point would be the privacy of communication. If it violates the right on the privacy of communication, even if the information is valid or relevant, then it is excluded by the rules. Now, before I leave this matter on admissibility of evidence, let me just add one classic example. Let's say, for example, there is an information was obtained by reason of a wiretap communication. Okay, there was a wiretap communication and he overheard a relevant matter. And the relevant matter pertains to the killing of Mr. X. The information is relevant, but if it was not, but if it is without a court order, that is excluded by the rules. So that is admissibility of evidence. Now, let us now move on to judicial notice. You know that judicial notice is Rule 129. 29. You are aware, okay? You are aware. Okay, you are aware. Okay, hang on. Hang on. Okay, I hope I'm still with you. Okay, am I with you? I hope I'm still with you because they said I froze. I hope that I'm still with you. Okay, so I will proceed unless I receive another notice. So as I was discussing Rule 129, okay, Rule 129, the first section is mandatory judicial notice. And for those of you who have studied the evidence, you would recall that mandatory judicial notice are mandatory because it is readily verifiable, it is established, it's readily accessible. That is why what you will find there is laws of nation, history of nations, political history of the Philippines, measure of time, because it is readily verifiable and established. So the courts are expected to take mandatory judicial notice. And the courts are likewise expected judicial notice of official acts of the legislative, executive, and the judicial department. It has been there for the longest time of the Philippines, except that the drafters inserted national government. Okay, national government. Now, what is the reason for the insertion? Sabihin mo sa akin, sir, parang namang ano na yan, parang maliwanag naman. Yes, it is clear. However, let me give you a little background on this. You know that has always been an issue as to the court taking judicial notice of an ordinance. You remember that? The court taking judicial notice of an ordinance. So, if you recall the case of SJS Society involving the city of Manila, the Supreme Court was confronted with the question on whether or not it could take judicial notice of an ordinance of the city of Manila. And the Supreme Court said, we cannot take judicial notice of the ordinance of Manila, although there have been repeated jurisprudence, old jurisprudence that says courts can take judicial notice of an ordinance. So where do we stand? I would want to be very clear that with the insertion, our courts are not expected to take judicial notice of these ordinances. Okay. However, local or trial courts within certain jurisdictions, and when their charters provide it to be, they are expected to take judicial notice of ordinances within their jurisdiction. Now, let us now proceed. Section 2, there is no amendment. I will not touch on that. Section 3, there is an amendment. Now, if you would recall, some students would ignore Section 3. They would always remember mandatory and discretionary, but they at times forget Section number 3. Section number 3 is important because Section number 3 tells us, please take note of this, that any matter could be subject of judicial notice. Kahit ano, pwedeng take judicial notice. Now, before I discuss that, sasabihin niyo, may tatanong sa akin ngayon sigurado, sir, anong klase? Any matter. O unahin ko na yon. Sir, what do you mean any matter? For example, Ondoy, if I'm not mistaken, in 2009, you could ask the court to take judicial notice of that fact. Now, based on the provision of the law, you could call the attention of the court during pre-trial. This is the amendment, during pre-trial and trial, okay? And the next amendment is the word request, okay? The intention or request, the request, was replaced with a motion, to be very clear. Because now, the court could take judicial notice of any matter upon its own initiative or upon motion of the party. Ganun yun. So, sir, any matter? Yes. During pre-trial, during trial? Yes, any matter. Sir, is there a need to present evidence? No. The purpose of the hearing is solely to ascertain, and this was another insertion, to determine the propriety of the matter subject of judicial notice. So you will have to justify to the court, at least explain to the court why the court can take judicial notice of the same. Now, there is a second paragraph. The second paragraph basically was not changed, except for the insertion of the word motion. Just like the first paragraph, the court in its own initiative or upon motion of the party. Now, the court upon its own initiative remains, but the word request was replaced by a motion. So how it works remains to be the same. Ito, dagdagan ko na lang ha, hindi ito amendment. Hindi ito amendment. Just to see the difference, bakit yung during pre-trial, any matter, after trial, or on appeal, you are, you could ask the court to take judicial notice, but you have to be limited only on what? On matters which are decisive of the outcome of the case, or to be very specific, decisive of the material issue in the case. Now, let me now proceed to judicial admission. Judicial admission is under item section number 4. Sir, binago ba yon? The concept remains to be the same. Judicial admission, and it because you did not contest a provision, then it is deemed as an admission. As you know that. You know that. Okay. Am I, let me just check. I will just pause very briefly. I will just pause very briefly. I'm back because they say I'm good. Okay. Now, I'm back. As I said, judicial admission could be at any stage of the proceedings when you have a judicial admission. But the only provision that was changed there was, or imputed admission was not in fact made. This was a replacement of the phrase, no such admission was made. Now, would it be is it a better wording? I believe so. Because lawyers have the tendency to make imputations. In a pleading, they would say, oh, you filed an answer. You did not specifically deny. And therefore, you have admitted it. That's an imputation. So this, I think, is a better wording. Okay, when it says the imputed admission was not in fact made, there is no such admission. So that gives us certain leeway to be able to contest imputations of admissions. Now, let us now proceed with documentary evidence. Let us now proceed with documentary evidence. Now, some of you may be surprised. Sabihin mo, sir, parang naging complex. Parang humaba ito. Okay, as you know, before I start, we are now on Rule 130. There are 3 basic classifications. We have object, we have documentary, and we have testimonial. We will take a great time, okay, to discuss documentary and testimonial evidence. Object evidence was remained unchanged. It is subject to the senses of the court. So I will now proceed to documentary evidence, which is found in Section 2 of Rule 130. Now, okay, as you know, in the past, this is the wording of, of the law when it comes to documentary evidence. It consists of writings, okay, or any material containing what? Letters, words, numbers, figures, and symbols or their equivalent. So yan yon. However, kindly take note that the times have really changed. That is why the amendment considered number one, recording is now part of definition of document. What else? Photographs are now included. Now, what's the basis? There is jurisprudential basis in considering it as what? Documentary evidence. This is by reason of the case of People versus Zeta. It's a May 27, 2008 case. Okay. And what's the third? Sounds. Okay, sounds. So now you have additional types of documentary evidence. Number one, recording, photographs, and sounds. But you have to take note that this should be offered as proof of their contents. I would like to be very clear with this. So the recording, the photograph, and the sound should be offered as proof of the contents thereof. Now, the provision, the photograph has now been what? Defined. Okay, what it includes. That is a new provision. That was taken from Mueller versus Kirkpatrick, a long-established authority in evidence. And what does photograph include? It includes still pictures, drawings, stored images, X-ray films, motion pictures, or videos. Now, let me highlight for you drawings. Sir, pati drawing kasama na? Yes. That was discussed in the case, not a Philippine case, a US case, Sailor versus Lucasfilms. That is why drawings is included in the definition of a photograph. But please take note, and I would like to be very clear with this, based on US authority, that the enumeration I mentioned is not exclusive. I will repeat, the definition I gave you, based on the provision of the law, is not exclusive. Therefore, if at some future time the Supreme Court feels that there are other items that may be included by jurisprudence, then it may be included. Now, some of you may be a bit puzzled at this time. Sasabihin ng iba, parang nadaanan ko na yan ah. Parang yung mga libro na binabasa ko, yung X-ray, photograph, video, audio recording, these are object evidence. Yes. But now, it has been covered by documentary evidence. But be very careful. For as long as the photograph, the recording, the sound, or the drawing are offered for what? As proof of its contents. I would like to be very clear with that. Because, for example, it will remain to be an object. Kung camera, pinampokpok ko sa'yo, object yun. Object evidence, you were hurt because of me using it to hit you. Okay? So, but this remains, okay? If you use that in good context, that's object. But if you use it to what? To prove what it contains, then it is documentary evidence. And kindly take note, wherever it may be found, okay, wherever it may be found. Letters may be on a shirt, letters may be on a wall, for as long as the contents thereof are the subject of the proof. Now, let us now proceed. Okay, let us now proceed. I hope that that's clear. No, let us now proceed with the original document rule. Okay, the original, sir, sandali. Di ba best evidence rule yan? Yes, that was originally the best evidence rule. And it has now been replaced. The title is original document rule. Sir, is the rule still the same? The answer is yes. Okay, I will expand the discussion. The answer is, sir, what do you mean? When the contents of the document is the subject of the inquiry, you will have to present the original. That is the rule. That is the best evidence rule. The title has been replaced. Okay. I hope I'm back. I hope I'm back. I was lost there for a while. Okay. I was lost for a while. Just tell me if I'm back. Okay. So I will continue. Now, I will repeat from where I was interrupted by the connection. Kindly take note that under the old rule, it was the best evidence rule. Under the present rule, it is now the original document rule. Is there a change in the manner of the appreciation of the rule? The answer is no. And let me recite this for you. When the subject of the inquiry is the contents of the document, you will have to present the original document. That is the rule. It is now the original document rule. Except that, tandaan nyo, originally, it was only limited to documents. Nung araw, limited lang yan sa dokumento. But now it extends to writings, as I mentioned to you a while ago, writings, recording, photographs, or other records. Ganun yan before, okay? So, yan ang dinagdag. Dati dokumento lang. Ngayon kasama ng writing, recording, okay? Photographs, or other records. Please take note of that. Now, according to the drafters, that was really a misnomer kasi. Alam nyo, ako, agree ako doon completely. I completely agree. Bakit? As a young lawyer, I see the practitioners making objections of this manner. When there is a question pertaining to the document, anything about the document, the other party will object. He will say, objection, Your Honor. The document is the best evidence. He is just testing the ability of the witness to remember what it was. It's not even a violation of the parole evidence rule that he tries to introduce something else. The question is just, could you please tell us, and this is a question in connection with the document, could you please tell us what the compensation is? Objection, Your Honor, the document is the best evidence. Oh, okay, wrong. So with this, I think this is more accurate now, that if the document, the contents of the document is the subject of the inquiry, now includes recording, photographs, or writing, you will have to present the original. I hope that's clear. Now, I will now move on to the exceptions. Naku, mahaba ito. I don't intend to discuss all of those. But of course, I will give you a rundown para makita natin kung saan ba ipinasok. Okay? The exceptions are more or less intact. But there are two new concepts introduced. Let me give you a rundown of the exceptions. Number one, the document has been lost or destroyed, so you cannot expect to present the original. Number two, the original is in the custody of the other party that despite notice, he refuses to present it. Okay, and this is where one amendment was inserted in this item B. Ano yun? Or the original cannot be obtained by local judicial processes or procedure. So, doon ipinasok yan. So, meaning, the court may have issued the processes, a subpoena, duces tecum, but despite issuance of the processes, what? The original cannot be obtained. Can you present secondary evidence? Of course. You could present what? If I follow this concept of subsection B, you could present a copy, recital in some authentic documents, or testimony. But if you will look at the provision of secondary evidence, the subsequent provision, there is nothing that expressly applies to this. So I would say, because it falls under B, okay, how to prove document in the custody of the adverse party will be the same manner as you will prove it, or to lay the basis for presentation of secondary evidence. You will have to establish execution, okay, existence, and the fact that what? There was application for judicial processes, but the original was not obtained. Now you could present a copy, recital in some authentic documents, and testimony. Okay? Now, sasabihin nyo, sir, saan ba kinuha yan? Naisip lang ba yan ng drafters? No. That was based on the case of PNB versus Olila. That is a 1956 case, 98 Phil 202. Okay? Now, let us now proceed with the rest of the exceptions. Okay? Of course, you know that when the documents are so numerous, okay, numerous accounts, and it will entail a great loss of time. It will be a great loss of time if the same will be presented. And when what you intend to produce is only to establish is only the general result. Yun lang naman ang gusto mo establish. Yung general result. So let's say, let's illustrate. Ganito to kakabala ang dokumento. Siguro mga 2 feet lagay na natin. 2 feet yon, at all you need to establish would be the profit and loss of the company for the last 15 years. Do you need to present all of this? If your intention is just to establish the profit and loss, you don't need to present all of this. All that the court requires is the general result of the whole. Now, in the past, sasabihin namin yan, summary, chart, graph, gano'n na sasabihin namin yan. Chart, summary, calculation. But that was not in the provision of the law. That was in US rules on evidence. So we have to some extent adopted it, but now it is now introduced. It is now part of our provision. And for those of you holding on to the new provision, you will find a provision on summaries. Okay. So this is the manner by which you present secondary evidence, because the documents are so numerous and it will entail great loss of time to present it. And all you need to establish is the general result. This is the provision that will apply. So what will you present? Not all of those voluminous or numerous documents, but I will present a chart, a calculation, or a summary. That would suffice. And that was also repeatedly declared since the case of Compañía Marítima versus Allied Free Workers, a 1977 case. So yan, mas maliwanag na. Dati wala yan eh. But again, we have nothing to worry because it is consistent with prevailing jurisprudence. Then the next one is what? When the original is in the custody of a public officer or recorded in a public office, remains to be the same. Hindi siya nagbago. Ito ang binago. At dito madalas tinatanong ng abogado. Okay, sabi nila, when the original is not closely related to the controlling issue. I will repeat, when the original is not closely related to the controlling issue. Ngayon, sabi ng iba, ano ibig sabihin ng controlling issue? So I will need to give you some background based on the discussion of foreign authorities. And this is through Mueller versus Kirkpatrick. This provision is truly an exception for collateral matter. Let me give you a little background. As you know, because you've studied evidence, in Rule 128, Section 4, what does it say? A collateral matter is that which has no relation to the fact in issue. So walang pakialam mga sagad. It has no relation to the fact in issue. But the court may consider this if it would tend to establish to a reasonable degree the existence of the fact in issue. Okay? So collateral matter, generally, wala yun. However, this, according to the court, is an exception. Okay, why? You don't need to present the original. An exception for collateral matter, according to Mueller. Examples are street names, license plates, billboards, newspaper headlines, commercial establishments, and brand names. Now, don't be worried. Sabi mo, attorney, masyadong medyo US. I think for our purposes, this is not far from our jurisprudence because we have numerous jurisprudence that says this. When the contents of the document is not the subject of the inquiry, sinabi lang, ito yung usual example, ay may deed of absolute sale. Hindi pinagtatalunan ko anong nasa loob ng deed of absolute sale. What are the stipulations therein? A photocopy of the deed of absolute sale will suffice because the contents of the same is not the controlling issue in the case. So, hindi tayo mahirapan intindihan because the contents in the document are not the controlling issue. It's not the controlling issue in the case. Let me give you also another example. For example, a plane ticket. Okay, a plane ticket. All I need to establish is that I boarded the plane. Okay? That plane ticket would be enough. Do I need to present the original? A photocopy would be enough. Why? I am not contesting the fine terms of the plane ticket, the contents of which is not the subject of the inquiry. Okay? Another example will be a billboard. Wag naman sana mangyari. I figured in an accident kasi nakatingin ako ng ganun sa billboard. Nabundol ako sa puno. Okay? Are the words or the contents of the billboard important? No. Well, what is important is, there was a billboard. Now, let us now proceed to what is an original. Ito rin, tandaan po ninyo. Ito ay nagbago. Okay? Nagbago ito. Makikita nyo, if you're holding on to the new provision, daming guhit. And this was taken from the federal rule of evidence. Okay? Pero wag kayong wag kayong mag-worry. Okay, mag-worry dito. Now, what is an original? What is the old rule muna tayo? Ang old rule, ang original, is when the contents of the document is the subject of the inquiry. Number 2, when the document is executed at or about the same time. And the rest are considered as duplicates. You remember that? And number 3, entries made at or near the time of the transaction. Yan medyo itantabi nyo na ngayon yan. Okay? Ano na ngayon? This is the one. Original of a document is the document itself. So the original is the original document itself, or it's what? Counterpart. Yep. Hold on. There is a specific definition of a counterpart. And whether it be an original or a counterpart, it is intended to have the same effect by the person executing it or issuing it. So kailangan daw, whether it be an original, or what? A counterpart, the effect is the same. And that is the intention of the one who issued it. Now, and considering that we have expanded, or the drafters have expanded, the definition of a document, okay? Now, the question is, what is an original of a photograph? What is an original? It includes, kindly take note, the negative or any print therefrom, okay? So any print from the same, a printout, yes, that is an original of a photograph. How about if it is a computer data, okay? Or that which is an output of a similar device as a computer, okay? What is considered as the original, okay? Any printout or other output readable by sight. So sabihin niyo, sir, parang familiar yan ah. Parang inaral na namin yan. Yes, not in the rules of court, not in the rules of evidence, but that is found. You could check that out in Rule 4, Section 2 of the rules on electronic evidence. Kaya sabihin niyo, familiar. So if it's a data, if it's an output or a printout of a computer or a similar device, that is considered as original. Okay, output readable by sight. Now, let us now define what is a duplicate, because a while ago we said that an original is the document itself, right? Or a counterpart, okay? Now, what is a counterpart? A duplicate is a counterpart. Okay, sabi yun, no? Ang duplicate daw is a counterpart. And for it to be considered, for a duplicate to be considered a counterpart, it should be any of the following. Number one, it has the same impression as the original. Okay, same impression as the original. Number two, that duplicate to be considered as a counterpart, it is from the same matrix. And number three, if it's by photography, it could have been an enlargement, it could be a miniature, or it could be a chemical reproduction or electronic re-recording. Okay, electronic re-recording. Again, this is a bit familiar to some. Do you recall? This is a bit familiar? Yes. Because of what? The electronic evidence rule. Now, let us now proceed to still on the provision on original. I hope that's clear. We have explained what is an original. An original is a document itself, and it's one. And its counterpart. And we have defined what a counterpart is. A duplicate is a counterpart. Now, can a duplicate, ayan, a duplicate, pwede ba nating i-contest yan? Yan ang tanong. Okay, can that be contested? Yes, a duplicate could be contested if it is what? A question of its genuineness is raised. The genuineness and authenticity of the document of the duplicate has been raised. Sasabihin niya, it is not the same as the original. I would want to contest it. Can you contest it? Yes, that's found in Section 4C of Rule 130. And the second way to do it is if based on the circumstances, it is unjust or inequitable to admit the duplicate. Okay, so based on circumstances, it is inequitable or unjust to admit it. Again, sasabihin nyo, sir, parang familiar yan. Yes, that was from the electronic evidence rule, taken that portion, Section 2, Rule 4. Okay, now, let us now proceed. Okay, kanina binanggit ko yung secondary evidence. I mentioned the secondary evidence now about summaries, but that is not complete. Sinabi lang natin if what is the document are numerous documents, and to present them will entail great loss of time, and all you need to establish is the general result. Ano man sabi natin? To present a calculation, to present a chart, or to present a summary. However, hindi pa pwede lang na ganun. Because the other party can copy or examine the same, and this is the procedure. This is the second part. This is Section 7 of Rule 130. Don't miss this out. While the other party presenting, who is not obligated to present the original, can only present a chart, can only present a summary, the other party or even the court can require examination or copying or both. Pwede sabihin, examine yan or copy yan by the adverse party. The court may allow it. Okay, I will allow it within a reasonable time and place. Okay, so the court may issue an order that they be produced in court. Okay, dalawa to, no? Posible, upon request, the court may see the reason for a copying and examination, and the court may designate a time and place. Or the court may require that the documents, okay, the originals be presented in court, produced in court. The answer is yes. Now, let me now just give you some insight of an experience that I have that hopefully this matter of summary will be very helpful to you. Ito ang tandaan ninyo hanggat sa maging abogado kayo, no? Lalo na yung mga estudyante, gaano man kakapal ang dokumento, if every document, if the contents of every document is the subject of the inquiry, you will have to go through the process of presenting every single document. I have at least 3 cases of what? Large-scale estafa prosecution. It took me numerous hearing dates to identify, to have my witness identify it, to have it authenticated by the person who executed the same. Okay, tandaan yun. Hindi mo pwede, ay, numerous, tabi ko na. Hindi pa pwede yun. You can't do that. The only instance that you could do away with the original, if the documents are numerous, if it will entail great loss of time, and all you need to establish is a general result. Okay, so what I discussed as to matters of procedure, wherein the adverse party could ask for a copying and examination, is a safety net of the law. That is a safety net of the law. Now, let us now proceed. Okay, let us now proceed with parole evidence rule. Okay, evidence. Makita nyo sa outline ko na makikita nyo, evidence of written agreement. Pero yan, nilagay ko na, parole evidence rule. Sir, marami bang nabago sa parole evidence rule? If you have a copy, isang word. Okay. Now, let me lay to you the rule. Okay? Let me lay to you the rule. Okay, sabi daw I'm okay, I'm back. Okay? Let me lay to you the rule. Parole evidence. What is in the 4 corners of the document, the terms in the 4 corners of the document, is the repository of what the parties have agreed upon. Therefore, we cannot go outside of the terms thereof. Therefore, if the compensation is 500,000, you cannot, by extraneous evidence or what you call parole evidence, and just, di ho, 1 million ng consideration yan. No. If the term is only for 2 years as reflected in the agreement, you cannot insist, ay hindi ho, 10 taon yun, because that will be in violation of the parole evidence rule. But again, the law, the rules, and the drafters thereof knew na kailangan yun, because there are instances wherein there were agreements subsequent to. Yes, the original document says 2 years, but we had a subsequent amendment of that agreement, an agreement subsequent thereto that says 10 years term. As you could present extraneous evidence as to validity, or if it does not reflect the true agreement of the parties, which is the most common, or there is imperfection, ambiguity, intrinsic ambiguity, or mistake. Okay? And that mistake should be a mistake of fact, not a mistake of law. Now, hindi yan nabago. Binanggit ko lang para meron tayong buong understanding yan for the students. What was inserted was the word verified. Now, why was it verified? For those of you who have taken up evidence, you will recall that for you to present all of those that I've enumerated, the exceptions that I have enumerated on the parole evidence rule, you will have to put it in issue in the pleadings. Tama? You have to put it in issue in the pleadings. And once you've put it in issue in the pleadings, you could modify, explain, and add it. Pwede mong patunayan dun sa pleadings mo, paliwanag mo na mali ho yan, dokumento na yan, mali yung pinipresenta niya, there was a subsequent document, or the document was actually different from what the parties intended. You could explain to the court, but you have to put it in issue in the pleading. What was inserted, sir, ang dami mong sinabi, pero isang word lang, ito kasi yun. It should be verified. Yun lang ang dinagdag. Ibig sabihin, sumpaan mo yung sinabi mo. Yung sinabi mo, it does not reflect the true intent of the parties. If you're telling me that there is a subsequent agreement, sumpaan mo yun. Dahil pag ikaw, biniro mo husgado, madidimanda ka. Ma-perjury ka dyan. Okay? So, please bear that in mind. That's the only insertion. And when you talk of verified, it should be under oath. Okay, there is an affidavit in support of your contentions. Now, let us now proceed. Okay, let us now proceed. Are we on time? Oh, we're good. we're good, ano? Magbibigay ako ng ano, no? I will give you a break pag mga siguro after an hour and a half or so, and then we'll proceed again. Now we will now continue with the. If you will see, you will notice in my draft, I will on my outline there is now testimonial evidence, and you will likewise notice that there is a deleted provision. Now, sabi mo, attorney, yung deleted provision na yun. Yung original section 21, yung disqualification by there was okay. I'm back. I have to be. We have to be very patient. I'm sorry about that. Uh, it happens every now and then. So let's continue. I was discussing, or I was elaborating on the deleted provision. That was section 21. That was the original section 21 of Rule 130. And what is that provision? That referred to or pertained to mental incapacity or mental immaturity, if you would recall. Okay? Wala na yan. It doesn't mean, though, that it's no longer a disqualification. I would want to be very clear with this. It doesn't mean that it's no longer a disqualification. Because if the person is insane, definitely he is disqualified to testify. But that is consistent with now the present section 21 on qualification of the witness. Has this been changed? No, it was not changed. Remains to be the rule, and it's a good rule, that the person to be a witness is able to perceive, and perceiving can make known his perception to another. I will repeat, the person is able to perceive with his senses, and perceiving could make known his perception when? At the time, of course, of his production in court. But at the interim, maybe immediately after the event took place, or the conduct took place, he narrated it, that's a different story. That may fall on other exceptions to the hearsay rule. But for our purposes, a person is qualified to be a witness if he's able to perceive, and perceiving could make known his perception to another. So therefore, even with the deletion of that, it doesn't change the fact that if a person is of an unsound mind, he is disqualified. Or if a child is a child of tender years, okay, let us say 3 taon pagte-testifyin mo, hindi pa pwede yun. In fact, you would recall, kindly take note of this for students, the child witness examination rule remains to be a good rule of the Supreme Court. And what does it say? It is the duty of the court, if confronted or presented with a child witness, to what? To conduct a competency examination. If the child knows what's right and what's wrong, a competency examination. And that is covered by the child witness examination rule that applies to a child witness, a child victim, and a child accused. Okay? Lahat yan, basta testigo na bata, covered yan. So, therefore, it is still a child, okay, could still be allowed to testify for as long as what? He is able to perceive and make known his perception to another, and therefore is competent to testify. Now, and let me just give you another example on mental incapacity before I leave this item completely. There are numerous jurisprudence that has allowed, okay? That has allowed what? That has allowed a person of slight mental retardation to testify. Marami yan, makikita niyan. Maybe he has a physical age of 48, but a mental age of 16. Can he testify? Yes, he could testify. This is where the court will have to ascertain the ability of the witness, though he may have some retardation, but only slight, to be able to perceive and make known his perception to another. Okay, now let us now proceed to another interesting change of number. Okay, makita nyo sa outline ko, ano makikita nyo dyan? Testimony confined to personal knowledge. Okay, so this is, if I'm not mistaken, presently section 22 na po ito. This is now section 22. But originally, this was 36. So pag may luma kayong provision, kunin nyo yung code, tingnan nyo 36 yung didiscussing ko. Na ngayon, nilipat lang sa 22. Now, if you look at the old rule, makikita mo, pagpasok nun, pagkatapos ng personal knowledge, exceptions to hearsay rule kagad. Napapansin niyo yun. But now, later on, you would note that there is a full definition of hearsay that we will discuss later on. Makikita nyo, a full definition. But for now, let's focus on this. You don't have to worry because this is consistent with, okay? This is consistent with the qualification of the witness. And what is that? That he has personal knowledge. That for a person to testify, he has personal knowledge. Or if you would want US concepts and jurisprudence, you would say first-hand knowledge. Okay, he has personal knowledge. And he was able to have the personal knowledge of the facts and circumstances that he is testifying on because he was able to what? To perceive. So that is consistent. The present 22 is consistent with section 21, qualification of witnesses. Now, punta na tayo. Di ba? Pag pinag-aaralan ito sa klase, qualification, diniscuss natin. Then we have disqualification. You remember? And one of the disqualifications that is very popular among students is the disqualification by reason of marriage. This has been asked a number of times in the bar exams. Ngayon, sasabihin mo, sir, nabago ba yun? Parang naman walang nabago. Konti lang yung linya eh. Mukhang walang nabago. Itong major lang na nabago. In the past, if you look at the old provision, it says for and against. Therefore, the prohibition to testify is what? For or against. So if you will support the declaration of your spouse, let us say akusado, or party sa kaso, pwede, ano yun? Bawal yun. For, bawal yun. Noon, bawal yun. In support of the spouse, di pwede. Kasi it says for or against. Okay? But now, that preposition of for was dropped. Okay, dropped. So what was retained was only a testimony against the spouse. Yun na lang ang disqualification. Okay? So, sasabihin mo, sir, the wife or the husband cannot testify in favor of the other spouse. Yes. Hindi ba, sir, ano yun? That will be self-serving o sasabihin niya lagi in support of. The drafters were aware of that. But again, we have judges who are expected to scrutinize every testimony, to judiciously understand the evidence presented. So wag tayo mag-worry doon. So 4 was dropped. Okay, now, so it is now clearly limited to what? Adverse spousal testimony. Kasi rin naman ang jurisprudence, sinasabi adverse spousal testimony. Okay? But the original provision says for and against. So the 4 was dropped. Okay? And the reason for this, why do you have this? Disqualification. It is to promote the harmony of the marriage, di ba? That is the reason. And if you would recall the case of Alvarez versus Ramirez, a 2005 case, ayaw mag-test, sabi nung lalaki, ayaw kung mag-testify ka. Sabi nung gusto palang ipatestify yung lalaki ng asawa na babae kasi there's a criminal case and she wanted to testify against the husband in a criminal case. Dahil nga namatay yung kapatid niya, nasunog eh. Okay? Ano nangyari? Inalaw ba ng court? Siyempre, ni-raise nung lalaki, no, you cannot testify against me. Sabi niya, you cannot testify against me. Though it's an adverse spousal testimony because we remain to be married. And that marriage is a valid and existing marriage, sabi niya. Pero papaikliin ko na, nung umakyat sa Supreme Court yung tanong na to, sabi ng Supreme Court, yes, while you remain to be married, you have been separated in fact for quite some time, and strained na talaga ang relationship ninyo, and there is no harmony of marriage to promote, sabi ng court. So therefore, hindi nag-apply yan, adverse spousal testimony. I hope that I explained that to you. Now, pasok na tayo dito. Pasok na tayo rito, no? This will be interesting for you. This will be interesting, and I hope you will bear with me. Let us walk through this, no? We will walk through this, and sana makadagdag ito sa inyo. Privileged communications. This is covered by Section 24, still Section 24 of Rule 130, the same number. I think I'm back. Okay, my screen was frozen again, but I think I'm back now. So I will continue. So as I said, Section 24 covers privileged communications. The same number as the old rule, you have the same rule, privileged communications, but there are a lot of amendments. Okay, Section 1, subsection A, pertaining to what? Pertaining to marital privilege, unchanged. Okay, dito tayo ngayon. But before I proceed, I would want you, most especially students, to take note of this. What do I want you to take note? Number one, as we discuss privileged communication, remember that's rooted on relationships. Relationships may be filial relationship, maybe husband and wife, maybe professional relationship, doctor, patient, attorney, client, okay, or a relationship with a public officer in relation to the state, relationship. And the second one is that in discussing all of these privileged communications, please take note that we're talking of what? In discussing this privileged communication, we're talking of confidential information, not just any other information, but confidential information. I would want you to take note of that before I proceed. Now, let me start with privileged communication, which is attorney-client. Okay, magsimula tayo sa attorney-client. Okay, now, what about attorney-client? Ito ang mga nagbago. Number one, not only is this attorney-client privilege limited to an attorney, but now extends to who? Someone who is reasonably believed by the client to be licensed to engage in the practice of law. So sa madaling salita, yung nagpapanggap, yung nagpretend na abogado, and because of this representation, the client believing that he is a lawyer shared vital information, confidential information. Is the person pretending to be a lawyer covered by the privilege? Should he keep the information confidential? And should he be prevented from testifying? Should he want to testify? The answer is yes. Okay. Now it extends beyond that. So all those who pretend, or those who is reasonably believed by the client to be licensed to practice law, are also covered by the privilege. Now you will tell me, attorney, paano patidisbar yun? Hindi naman abogado. Bakit yun lang ba pwede mo siyang habulin? You could sue him civilly if you suffered damages by reason of his actions. You could even sue him criminally if there was fraud that he committed or any other offense that he committed. So pwede mo pa rin siyang demanda civilly or criminally. So number one, reasonably believed to be a lawyer. Number two, the coverage of the agency is now expanded. Sir, sandali. Because class, before the amendment, this is attorney-client privilege is the only privilege that extends its privilege to a secretary, stenographer, or clerk. Original provision yon, hindi yun bago. Secretary, stenographer, and clerk. And let me give you some insight on this, no? Let me give you some insight on this. Bakit? Alam niyo, iba kasi ho ang ang relasyon ng isang sekretarya sa isang kliyente, lalo na sa kliyente ng isang abogado. Most of the time, pag walang abogado, lalo na pag medium size yung, hindi naman, yung small o single practitioner si attorney, lalabas, ang laging kausap niya yung sekretarya. And most of the time, the secretary hears confidential information from this client. Ganito sa manalum niya, ito nangyari sa kaso niya, hanggat makarating si attorney. If you would note, it extends to secretary, stenographer, and clerk. But based on the amendment, it now extends to those assisting the attorney. And who are those assisting the attorney? Paralegal, apprentice. How about the associate of the lawyer? Yes, extends to him or to her. Now, how about the private investigator? Actually, in some states in the US, extended yun. Basta assisting the lawyer. But I think I don't want to venture on giving an opinion on this because I would want to wait for the Supreme Court on this. Kasi hindi naman tayo lahat ng abogado gumagamit ng private investigator. Okay? And the next amendment on attorney-client privilege, ito is a rundown. The next important amendment would be a rundown of the exceptions. There are a number of exceptions. There are 5 exceptions. Okay? The first one is what? If the information received by the lawyer and shared by the client is in the furtherance of a crime, meaning to enable or to aid in the commission of the offense. Ibig sabihin, nakipag-usap siya, nagbigay ng information si client, hindi, attorney, ganito gawin mo to, i-divert mo tong pera na to, in violation ng anti-money laundering. Ay, alam mo, crime yun, hindi pwede. O attorney, ganito, iligpit na natin itong tao na to, hadlang lang to. Ay, hindi pwede yun, pagpatay ng tao, gani? So, you cannot use this as a shield not to testify, okay? If summoned or subpoenaed by the court, or even required to testify. Next, the next exception is claimants through the same deceased client. And I think this is a very good, this is a very good amendment. And for your guidance and for some professors who are with us, this was taken from the Federal Rule on Evidence 503, okay? Ano ito? Kaya I recall in most of my lecture reviews in evidence in the past, I've been discussing this. But kindly take note, claims through the same deceased client. As to communications, what? Relevant to an issue between the parties. And I would want to be very clear with this. Claims through the same deceased client. Sabi mo, sir, anong mga klaseng kaso nito? Yung mga wills contest, okay. Am I still my video? I hope that I was not interrupted again. Okay. So I was referring to claimants through the same deceased client. So when can you use this? In cases of will contest. Because to the mind of the court and the authorities in the US, sabi nila, uy, the lawyer will be in a better position if there are disputing heirs. If there is a will contest. And this will be a way to share to the court what is in the mind of the decedent during his lifetime. So a good example of this is a will contest. So that if you will complete the provision of the law, and let me quote a portion, whose claims are by the estate, by estate or intestate or by inter vivos transactions. Now let me backtrack a little. I was referring to what? Furtherance of crime or fraud. We have a jurisprudence on that. It is the case of People versus Sandigan Bayan. Okay, it is the case of People versus Sandigan Bayan. It's 341 Philippines 1997. Okay, now let us continue. Let us continue with the exception, the breach of duty by lawyer or client. As you know, the attorney and the client have what you call a fiduciary relationship. It's a trust relationship. Therefore, pag binreach, binilate ng abogado ito, pinakilaman ng abogado ang property ng kliyente, pinakilaman ng pera ng kliyente, or hindi ginawa yung duty niya bilang abogado, negligent siya, pwede siya idemanda. That is what a disciplinary action. The lawyer cannot invoke, attorney-client privilege, no. In the same manner, if the client breached that relationship, ayaw magbayad ng kliyente, the lawyer was forced to sue the client for professional services, then the client cannot invoke the privilege. The fourth is a document attested by the lawyer. And please bear in mind, document attested by the lawyer. Please bear in mind that here, the lawyer is not really a lawyer in a strict sense, acting as a lawyer in the course of or in view to a professional engagement. Hindi talaga. His engagement here, or his participation, to be very specific, is only to attest to the document, okay? And therefore, he is just an attesting witness. In pure and simple words, he is not acting as a lawyer, but as an attesting witness. Therefore, the privilege of attorney-client will not be applied. He cannot use that shield. And finally, the last exception is the joint client, okay? And this is very common today as to communications relevant to a matter of common interest between two or more clients. For example, ako'y abogado, meron akong 5, 7, 8 kliyente na meron silang common interest sa pagkakataong ito. But definitely, they will also have their own separate individual interests. But in that particular instance, because it's in one case and they have a common interest, there is a free flow of information. And information that they share is, to their knowledge, not intended to be confidential among themselves, right? Okay. However, when they have a suit among themselves involving the same matter, okay, the same matter, that they have consulted the lawyer, okay, that is an exception, okay? That is an exception. The lawyer cannot invoke, hindi ho pwede. That is an exception. But you could safeguard that information. Okay, for practitioners listening, you could safeguard that information if it was stipulated, if it was agreed otherwise. So kung marami kang kliyente, lagay mo dun sa engagement letter mo na yung nagkakasundo sila para hindi malagay sa alanganin yung abogado. Baka magalit pa sila sa iyo. Okay, now, let us now proceed to the next privilege communication. Okay, I will now proceed to the doctor-patient privilege. Okay, doctor-patient privilege. What were the amendments? Tandaan nyo to. In the past, di ba, doctor of medicine. Yun lang yun. Pag tinignan nyo yung old rule, doctor of medicine. Now, it has been extended to not only a doctor of medicine, but to a psychotherapist. A psychotherapist, and number 3, person reasonably believed to be licensed to what? To practice medicine or psychotherapy. Okay, yun po yun. So ngayon, hindi lamang yung hindi lamang doctor of medicine, including psychotherapist, and those who are what? Reasonably believed to be either a doctor or a psychotherapist. Or marami akala doctor sila eh. Okay? And kindly take note that the application of the privilege remains to be limited to civil cases. Okay? The privilege cannot be invoked in criminal. It's still the same rule. Walang nagbago doon. Ang unang nagbago, sinabi ko, inclusion ng psychotherapist, inclusion ng reasonably believed to be a doctor or a psychotherapist. Okay, now, kindly take note also that to some extent, the communication or the information received by the doctor and now psychotherapist was a bit expanded, because in the past, advice, okay, or treatment The communication received by the doctor in confidence to give what? Advice or treatment. But now, it is what? To diagnose, okay, for purposes of diagnosis or treatment. So wala na yung advice na yon. Ano na yon? Diagnosis or treatment. Diagnosis was inserted. And now, it's no longer limited as in the past to physical illness. Ano pa? Or information obtained by reason of what? Physical condition. What else? Physical, mental, emotional. And now even includes what? Drug addiction or alcohol addiction. So mas malawak na. And what do you think is the reason for this? I think most of you listening to me right now will agree na dapat na ito. Because in the past, when the old law was drafted, was the wordings were framed in the late 80s. Late 80s ho kasi ang old rule nung naipasa yon. Hindi ho pinag-uusapan minsan yung doon ang mental condition para ang tao'y nahihiya. In the US, it has long been there. That is why if you would note, ang ginamit dito psychotherapist, which is very US. Psychotherapist. And later on, I will give you the definition of psychotherapist. Okay? So now it's physical. The coverage of the privilege extends of physical, mental, emotional, and even drug or alcohol addiction. Okay, now, kindly take note. Okay, kindly take note now of its application. Ngayon, meron na siyang agency para na sa attorney. In the past, wala. Doctor-patient lang. Ganun yun. But today, kindly take note, ngayon, ano na to? Tingnan ko lang. Okay? Ngayon, it only applies also to members of the family. So it now includes members of the family who were there in the diagnosis or treatment. Okay? Diagnosis or treatment of the patient, or all other individuals may be assisting the doctors under his direction of the physician or psychotherapist. And I would want to highlight the phrase under the direction. Okay? Under the direction of the doctor, the physician, or the psychotherapist. Now, let me give you, sirs, ano ba itong mga example na ito? Okay? Ano to example ito? Number one, yung mga nurse. Okay, pangalawa, yung medical resident. Tapos yung mga clinical assistant na talagang nandoon pag ginagawa yung proseso. Okay? Now, the last important amendment in doctor and patient privilege is now the definition of a psychotherapist. Again, as I said, this is very American, but I think this really applies to us also because a person who is licensed to practice medicine, okay, take note, and engage in the diagnosis or treatment of mental or emotional condition. Now, in the Philippines, kindly take note, yung may mga magulang na doktor, mga kapatid na doktor, alam niyan, pag sinabi sa pag-iisip, psychiatrist yan. But if you will read the provision of the law, it does not limit itself to psychiatrist because it says a person licensed to practice medicine and engage in what? Diagnosis or treatment of mental or emotional condition. Now you will tell me, sir, meron pa bang iba? Yes, mga family doctors, pwede. So that is why, to some extent, we will have to wait until new jurisprudence will be touched on by the Supreme Court in this matter. Will it just be limited to psychiatrists? But how about other doctors of medicine who, to some extent, give what? Diagnosis of a mental condition or emotional condition. And the second one is, which is really known to us also, that falls within the definition of a psychotherapist, is a psychologist who is licensed by the government. Okay. So I hope that was... And finally, sandali, bago ko makalimutan, doctor and patient, itong wala na. Okay? Maganda to, itong wala na. The phrase, that which would blacken the reputation of the patient has been dropped. Okay? That which would blacken the reputation has been dropped. Now, let us now proceed to penitent and priest. Yan, punta na tayo sa penitent and priest. And what about the penitent and priest? Now, let me give you a general idea of what it is, this privilege is. Yung estudyante ako, naalala ko, lagi ko ito naalala kasi ang tinatandaan ko to, it is of a penitent character, penitential character. Okay? And if you will look at the old provision, balikan niyo, may kopya kayo, tingnan niyo. Ang nakalagay doon, person making confession. So it was very limited to making penance, to making a confession. And that is why, this is based on US authorities, hindi ko po sinabi ito, sinasabi doon ng mga US authorities that this favors the Roman Catholic Church, sabi nila. Ito'y pabor sa mga Roman Catholics. And sure enough, because they have a sacrament. They have that as a sacrament. And the rule on the matter, the religious rule on the matter is very clear. But now, with the amendment, it is now expanded in terms of its application. Now, it includes non-penitential communication. Okay, it includes non-penitential communication. Sabihin mo, attorney, ano yung non-penitential? As a spiritual advisor. But kindly take note, in all of this, as I told you, it should be in a confidential nature. The communication should be in a confidential nature. Okay. So, spiritual advisor pala, attorney, kasama na? Yes, spiritual advisor ay kasama na. Okay. Spiritual advisor, sandali lang po, tinitingnan ko lang kung, no. I thought po, may reminder sa akin na nawala ko. We're okay. So, I will continue. So now, it extends to a spiritual advisor, but I would want to tell you this. I would want to remind you, should you handle a case of this nature, always remember this phrase, and which was part of the old and the new unchanged. In the course of the discipline, enjoined by the church to which he belongs. So dito, magkakaroon tayo ng tanong. Ang tanong natin dito, enjoined by the discipline to which, okay, you belong. Okay? So we have to look at, ang tanong dyan pwede ho ba oral sinabi that is a practice in our church or in our denomination? That's one. That's an important question. Second, should it be a written rule of the religious group? Because based on the provision of the rule, in the course of the discipline enjoined by the church to which the minister belongs. So this is another, I don't want to say problem area, but a point of concern that the Supreme Court may give some enlightenment in the future. Because sa akin po, sa aking pananaw, para kung ako ang judge na, tatanggapin ko lang yan kung maliwanag sa akin ang rule. Kung sasabihin mo sa akin, hindi, sinabi ko, hindi ho pwede magsalita yung aming priest, ay aming minister, pastor, kasi confidential, sabi ko confidential. No, the qualification is it should be enjoined by the discipline to which he belongs. And of course, there should be a rule. Okay? Now, let us now proceed to the next. So tapos na tayo sa penitent and priest, punta na tayo sa public officer and the state. Ito yung sinabi ko sa inyo. In fact, this is the only privilege among those privileges that I have discussed in section 24, where the partner is not an individual. It's a public officer in relation to the state. Tama? The change here is not really material. Hindi naman ganun kalaki ang pagbabago. Bakit? Ang binago lamang is yung phrase. Originally, it was during his term. A public officer cannot be examined. Ito yung original. During his term or afterwards. Okay? For communications that he has received in confidence. And that during his term or afterwards has now been replaced with a more accurate wording. During or after his tenure. Yun lang ang pinalit. Pareho pa rin ang effect. During or after his tenure. If the disclosure, okay, so that is a privilege and will not be allowed, the public officer will not be allowed to disclose if the public interest will suffer. Okay, now, and before I leave this section 24, I would want to call your attention on the last paragraph. Tingnan po niyo yan, hindi lang yan nag-a-apply sa isang provision, pero pahabaho yan ganyan. Okay? Therefore, it applies to all the privileged communications under section 24. Now, before I proceed, kindly take note that it appears that the mindset of the drafters would be to protect the confidentiality, even if there is a spillover, if it passes on to the hands of third persons. And the only requirement of the rule, or the standard laid down by the rule, is that the original parties to the communication took what? Reasonable precaution. And I would want to highlight that phrase. They took reasonable precaution. I will repeat, the original parties took reasonable precaution to maintain its what? Or protect its confidentiality. So ganun yun. Ganun na yun. Doon sa diniscuss ko, nag-a-apply yun. So if by chance nag-spill over yan, if the intention is it's confidential, okay, it's confidential, and there was reasonable precaution, then it is treated as confidential. Dadagdagan ko kayo ng konti example. Babalikan ko yung sa mag-asawa. Okay. Yung sa mag-asawa, babalikan ko. Let's say, kapapanganak pa lang ng mag-asawa, nag-uusap sila. Ang nag-aasikaso, very common sa Pilipinas, yung nag-aasikaso yung kapatid na bata. And then mention na pag-iusapang confidential, alam mo, ako yung ako yung hold up ng bangko eh. Narinig niya. Okay, narinig niya. If we follow the provision of the law, if they took reasonable precaution, talagang makikita mo based on the facts and circumstances, to what? To protect the confidentiality, then it may be invoked. Okay? So take note of that last paragraph. And that is a new provision. Okay? Now, let us now proceed to the next. Filial privilege. Ito'y iba. Filial privilege. Still privilege, but again, it's a different category. Meaning, what is the amendment? Okay? The amendment is just on the exception. I don't want to use that to say just, no? Kasi material yun eh. Okay? The exceptions. But the rule is still the same. I, let's say, cannot be compelled to testify against my father. I cannot be compelled to testify against my son. Okay? Unless that testimony is indispensable, okay, in a crime committed by my father against me. Okay? Or a crime committed by my father against my mother. Okay? So kindly take note. But there's one thing I would want you to remember, and very clear in our Philippine jurisprudence. The use of the word cannot be compelled. Therefore, in a case decided by the Supreme Court, kapatid ako, meron ni-rape yung kapatid kong babae ng aking ascendant. In-invoke ng ascendant, no, you cannot testify, you're my son, sabi niya. But, okay, in the case decided by the Supreme Court, I was allowed to testify for my sister, who was the victim. Why? Because it was voluntary. Okay. Now, and please take note, you could make a small notation, the exceptions were taken in Article 215 of the Family Code. Now, let us now proceed to the next. The next is privilege relating to trade secrets. Okay? Privilege relating, ayun, siguro pag nadala niyo yung outline niyo, nasa next page na ako na outline na. Privilege relating to trade secret. Okay? A person cannot be compelled to testify on matter about any trade secret. So hindi mo pwede, you cannot compel him to testify. But please take note, this is not absolute. This is based on U.S. authorities. This is not absolute. And kindly take note that the root of this case is a jurisprudence, a U.S. jurisprudence with the title of Floridine versus Atapulgos Clay. Yan po yung ruling case dyan. Okay? So this is not an absolute privilege. And although you cannot be compelled to disclose a trade secret, except it is used to conceal a fraud, number one. Number two, if to hide it or not to disclose will work injustice, can the court issue an order? Yes, the court may direct. Okay, may direct. The court may direct the disclosure. So the court may order the disclosure for as long as the court should take protecting measures. I will repeat, the court will have to take protective measures to protect the interest of the owner and the parties. Okay, so measures should be taken to protect, or measures taken to protect the interest of the parties or the owner. And number two, in the furtherance of justice. Okay, so let's be very clear. Now, before I proceed, and this is the last point, sir, merong umiikot ngayon, yung journalist and source. In fact, in one of my lectures, I made mention of that. And the jumble was really brought about by the matrix moving around in schools, nasa mga estudyante, nasa mga professors. All of that we will discuss here, andun, except that there is journalist and source. But I would want to be very clear that the journalist and source was not part of the approved version of the Supreme Court in Bank. So hindi siya kasama. Pero huwag kayo mag-worry, sabihin mo, sir, gusto ko to, maganda to. Lalo na ngayon, ang daming nagfe-fake. Ayan, sabi niya, nagfe-fake na news. You know. Ano ngayon? Huwag kayo mag-worry. Because you have RA 11458. Sir, hindi ba RA 53? Oo, yun ang root. Kasi nga nag-evolve ito eh. And significantly, kung di ako nagkakamali, RA 53 is known as the Soto Law. Yung isa sa nakapirma doon, Senate President na siya, that was in 2019, 11458 RA, si Senator Soto. Okay, si Senator, trivia lang naman yon. Yung apo na niya yun, apo na ba niya yun? O apo na nga niya yun ata. Okay, now, but you will see the evolution from 53 RA 53 naging 1477, naging 11458 ngayon. Now, very briefly, the publisher, the editor, the columnist, the reporter cannot be compelled to disclose the source of information or media. Hanggat na-amend yan, isinama niya ng broadcast. Okay? Sinama dyan ng, originally print lang yan, naging broadcast. Then, wire service, electronic mass media, even cable are now included, TV and its variants. So today, covered na lahat yan. And there is no, they cannot be compelled to disclose it unless the court, that's the exception, under RA 11458, unless sinabi ng Senado, i-disclose mo yan, or sinabi ng House of Representatives ng Senado or any of its committees. Okay? Now, let us now proceed. Now, before I leave this item, tapos na ako sa privilege, no? Do I have, okay. In a while, I will give you a break. No? In a while, I'll give you a break. Buuin ko lang tong privilege communication. And then, as you know, there are some privileged communications which are not even under the provision of the law, if you would know, right? But in jurisprudence, judicial privilege. There is executive privilege, universally recognized. Okay, executive privilege. There is diplomatic privilege. Okay, there is also what you call bank secrecy law privilege, RA 1405, and the Foreign Currency Deposit Act. Yan, mga privilege yan. Na even if they are not in the provision of law, they're recognized. Non-disclosure of who you voted for, non-disclosure of the results of the census, all of this are well-recognized privilege. Now, let us now start with, at palagay ko, dito ho ako magbibigay, sandali muna, hindi pa ako magbe-break. Didiscussing ko muna ang offer of evidence. And after I discuss offer of evidence, or offer, not offer of evidence, offer of compromise, then I will give you a break. Tapusin ko lang ho itong slide na ito. Okay? So that when I give you a break, magsisimula ano tayo. We will be starting on hearsay. And that will be a good point to start for the second part. Okay? Now, let us continue with offer of compromise. As you know, every single law student and every lawyer would know that an offer of compromise in a civil case cannot be considered as an admission of what? Of liability. Or it is not even, the offer itself is not admissible in evidence. That's the wording of the law. And remains to be the rule, old and new. Okay? And neither is the conduct. Yung conduct mo, or even your statement towards the compromise, offer of compromise, will be considered by the court. Except, ito lang nga ngayon. May exception na ho ngayon. And itong babanggitin kong exception, ibig sabihin, kahit na civil case ito, kahit na nag-uusap tayo on a compromise, my conduct, my statement is towards a compromise in a civil case, ano yun? The following will be allowed. Okay? Okay, the following will be allowed admission. Number one, the evidence is otherwise discoverable. Okay? Or offered for another purpose. Meaning, if you find a way, you could still get that evidence, not through the conduct or the discussion. Another one is, it is offered for another purpose, such as proving bias or prejudice. Number three, the conduct or the statement made in the course of the exchange will negate what? Claims of delay, contention of a due delay. And that's good. And hindi naman ako nagdi-delay. That's good. It will negate any claims of delay. And three, proving an effort to obstruct a criminal investigation or prosecution. And I received a question on this point from a lawyer. Sabi niya sa akin ganito, sabi niya, hindi ba that because of this provision, some of the parties may be hesitant in talking of a compromise in a civil case, most especially in a commercial transaction, if there is what? If there appears to have been some effort to obstruct a criminal investigation, assuming or prosecution, assuming that the talks for compromise fails. Sabi ko, yes. Oo. So you have to be very careful also that you do not give so much information that it would reflect, okay, or prove that you will obstruct criminal investigation. I'm not saying that you should obstruct. What I'm saying is lawyers should know the information that they have to disclose, but you should not obstruct investigation or prosecution. Okay, now, I think, wait, this is my last point. Okay, last 2 points before I give you a break. How about yung criminal cases na bago? Hindi. Remains to be the same. An offer of compromise in a criminal case is an implied admission of liability. Now, there is no change. Here, there is a change. Offer of compromise Okay? When there is a plea of guilt withdrawn or an accepted offer. So there is an amendment on that point. That which relates to statements in the course statement made in the course of a plea bargaining. Alam niyo naman, plea bargaining. Aminin ko na lang, theft, robbery ang demanda mo, estafa ako, other deceit na lang ako, pwede. Ganun yun. Murder, homicide na lang. Ganun ang usapan. So, is that something that could be taken against the accused? No. If the plea bargaining was unsuccessful or it did not result to a plea of guilt, it cannot be used against him. It will not be considered as an admission. Or even if there is already a plea of guilt, but later the accused realized, I would want to withdraw, it cannot be used against him as an admission. And that is followed from the view of Mueller versus Kirkpatrick. Okay? Now, I will give you a short 15-minute break. I'm back. At dito na po ako muli at we will continue with the second part of our presentation and discussion on the amendments on the rules on evidence. Okay? Ngayon, it's a good break kasi we will be discussing something which is really new. And to some, this you may have some resistance on this. Even to lawyers, they may have some resistance because the old provision on personal knowledge, as I mentioned in 36, was transferred now to 22. And hearsay has its own definition. Okay? Now, how is hearsay defined now? Based on the provision of the law. Hearsay is a statement, kindly take note, other than that made by the declarant while testifying at the trial. So obviously, it's a statement other than that which the person, the witness, is testifying in court. Sabi mo, paano yun? Diba? Sabi mo, paano yun? I think to be able to help you understand, it is an out-of-court statement. Okay? It is an out-of-court statement made by a witness. Kasi sa foreign jurisprudence, ginagamit nila at an out-of-court statement by an at-trial witness. So, just to simplify it, an out-of-court statement made by a witness who is now in court. Out-of-court statement. Okay? If it is hearsay, if it is offered of what? To prove the truth of the facts asserted therein. I think I need to give you some background for a better understanding. Ganito, no? The prevailing practice, and this is the practice before this amendment, of course, that we adopted from US, is this. All out of court statement, okay? Meaning, the established practice treats all prior statements of a witness on the stand exempted from hearsay. So kahit anong sabihin mo doon, for as long as you're subject to cross-examination, lusot yun. Okay? That was the prevailing practice. Kasi ang hirap nga naman i-ascertain eh. But of course, it doesn't mean that we will not ascertain what is hearsay and what is first-hand knowledge. Okay? And we will discuss that later on. So the prevailing rule before the amendment is everything that a witness will testify in court, even if it's out of court statement, is exempted from hearsay. Now, the present definition now means what? Makes an out of court statement by a witness hearsay. Okay? Not admissible as to the substance, okay, evidence as to the substantive evidence for the truth of the matter asserted. So hindi na siya pwedeng tanggapin out of court statement an assertion on the witness stand of substantive evidence of a fact upon which it is offered. Now, this definition likewise now defines what is hearsay. It is oral or written assertion. And even a conduct, even if just the conduct, it is also treated as hearsay if it is intended to be what? An assertion. Now, in the effort to make it more understandable, let us look at the type of hearsay. Okay? It is that which focuses on the type of the statement and the purpose for which it is offered. And I hope that with this example, we will have a good sense of what is hearsay and what is first-hand knowledge. Okay? Now, Joey, let's state a fact, an example. Joey was in NAIA 3 on October 10, 2019 at 4 p.m. Let's look at the variation, the first variation. If Joey tells me that he was in NAIA 3 on October 10, 2019 at 4 p.m. and the purpose of the testimony is that he communicated that to me. Okay, can I sit on the witness stand? If my purpose is to show that Joey communicated that to me, yes. Did I perceive? Yes, I actually perceived. I have first-hand knowledge that he communicated to me, that he told me that he was in NAIA 3 on October 10, 2019 at 4 p.m. in the afternoon. But as to the truthfulness of whether or not he is there is another matter. Hindi ko alam, sabi niya yun eh. Okay? And I think a great number of us would know, sabihin, yan yung independent relevant statement. That the truthfulness of his being present there will have to be proven independently. Okay? But to that extent, his communication to me, and if the purpose of my testifying is that, sinabi niya sa akin yun, nagkausap kami na sinabi niya, is what? is first-hand knowledge. Let us look at another variation. Okay? I am in court, the same witness who will testify, and I assert, Joey, sinasabi ko ito ha, Joey was in the year 3 on October 10, 2019. That is an assertion at 4 p.m. Naturally, that is objectionable. Because that is what? I don't have first-hand knowledge of that. And one could even object it on it as, oy, hearsay yan. Wala ka dun eh. Hindi mo rin mapatunayan eh. And that is the slippery slope when it comes to hearsay and first-hand knowledge. I don't intend to go on deeply on this because of our time, but I know that for those of you who are really interested, you have to look at it in the light of first-hand knowledge and hearsay. But I hope my example would give you some guidance. Now, if there is a definition of hearsay, there is also that which is not hearsay, okay? Or that would fall outside of the same exceptions. Statement is not hearsay if the declarant testifies in court, kindly take note of the requirement, testifies in court and is subject to cross-examination. Okay? Testifies in court and subject to cross-examination. Sabihin na lang, alam ko yan, ganun naman talaga eh. And which is the practical way of doing it. Basta dinala mo sa witness stand, okay, sa trial, subject to cross-examination, kaya lang nga, nilimit na nila eh because of the definition of the first paragraph. And you are only limited to the items which are enumerated here. 3 items which are allowable exceptions. And what is that? Inconsistent to the declarant's testimony. And para matandaan nyo, this is very simple. An inconsistent testimony, inconsistent with the declarant's testimony, which is under oath, could be subject of perjury. What is that? It is a prior inconsistent statement. So the purpose of which is to impeach on a prior inconsistent statement. So the declarant now is making an assertion in court, okay? The witness making an assertion in court, and then on cross-examination, he's been confronted on a prior inconsistent statement. Is that allowed? That is allowed. Okay, that's not hearsay. But considering that it is a prior inconsistent statement, kindly take note that you have to lay the basis of time, place, and persons based on the provision of the law. Second, another exception is that which is consistent with the declarant's testimony. Ito naman, hindi naman, ako yung testigo, hindi naman laban dun sa akin. Okay? Yung pinipresenta, out of court statement, hindi inconsistent sa akin. The first one is consistent, now is consistent. Why is it allowed? Okay, it is allowed based on the following narrow requirements. The purpose of putting this as an exception is to prevent or to cut the practice of some in using what? Affidavit, sabi ng ng mga authorities. Ginagamit affidavit tapos papa-attest yun. Okay, affidavit ipipresenta tapos ipapa-attest. And for all intents and purposes, that's an out-of-court statement. At dahil lang pinresenta, subject to cross-examination, pasok na. So, sabi ng authority, hindi na pwede yun. Although we have so many jurisprudence on that. Consistent with the declarant's testimony and is offered to rebut. Okay? So, ibig sabihin, you could present consistent testimony for as long as it is to rebut a charge against the person, against the declarant. If there is a charge, express or implied charge against the declarant, you could present consistent statement. Number 2, or a reason to rebut a recent fabrication or improper influence or motive. And to help you remember this, according to authorities, quote unquote, this is cumulative proof. Okay. Sometimes it could be superfluous, they say, but it is a cumulative proof. It is what? An evidence of the same kind or character to establish the same fact. Okay. The next and the last one of this exception is one of identification of a person made after perceiving the same. So what you have here is not an in-court identification. Iba yun. Kasi that subject immediately to cross. Sasabihin mo, nga, subject to cross. Hindi. What is contemplated here is an out-of-court identification. But why is it accepted here as an exception? Because they say that out-of-court identification is closer to the incident, okay? And the identifying party should be, if possible, available for cross-examination. So kung available sa cross-examination, so this is an out-of-court identification. Closer, and why is it reliable? Because it is closer in time to the event in question. Sabi. Okay, now, let us now look at the exceptions to the hearsay rule. Okay? Makikita nyo rito, hindi naman lahat na bago. Okay? Hindi lahat na bago. Dying declaration, hindi ko nadadaanan, hindi nagalaw. Ang una kong pag-uusapan dito, yun nasa section 39. This is altogether new. Rule 130, section 39. And what is that? Statement of the dissident or person of unsound mind. Now, why, first and foremost, mag-agree tayo. Why is it hearsay? Because what is presented to the court is the declarants, is the statement of the person of unsound mind or the deceased. Okay? And there is someone who may have received that declaration, correct? By its nature, it is hearsay. But why is it trustworthy and reliable? Okay? Why is it trustworthy and reliable? I will tell you. Okay? Now, I will tell you why it's reliable. It is reliable because it was made, that statement was made at the time, okay, when he has personal knowledge, upon personal knowledge of the deceased or the person of unsound mind, and when the matter was recently perceived, and while his recollection is still clear. Now, for a better understanding, let me discuss this further. Para makita natin. As I said, this was originally section 23. A great chunk of the same was section 23, which was transferred here to section 39. It was originally a disqualification, dead man statute yan noon. Ngayon, ano na to? Ngayon, this is now an exception to the hearsay rule. Bakit? Because the claimant, okay, the claimant, the claimant, the parties who claim, okay, or the assigners of parties to an estate of a deceased person or a person of unsound mind can now testify. Okay, yun ha. Noon kasi sa old rule, hindi sila pwede mag-testify, disqualified. Ngayon, pwede na sila. Although, hearsay ang sasabihin nila. In fact, I received this question from a student of mine. Sabi niya, sir, it doesn't make sense to me. Bakit ganun? Kung dati disqualification yan, ngayon pwede na sila magsalita. Hearsay yan. Pwede niyang sabihin everything that favors him because he's the claimant to the estate. Diba ganun? But again, the court sees the provision of law gives this a certain level of reliability. If the statement was made by the deceased or the person of unsound mind at the time that had personal knowledge, when it has been recently perceived, and while his recollection is clear. Now, of course, this is where the wisdom of our judges will have to come in. The judiciousness in determining, in assessing the kind of evidence. Because there is a provision in the law that says such statements, however, is inadmissible if if made under circumstances indicating lack of trustworthiness. So that is where our judges' determination will have to come in. Pero ngayon, sasabihin mo, ano ngayon, attorney, ang direction? Kasi ang direction dito, give him a chance to testify. Besides, hindi naman lagi yan magsisinungaling. Di ba? Besides, there is the case of Sansan, a 2003 case, that if a claimant raises a claim, he will have to support it with documents like contract, checks, he will have to support it. Ngayon, hindi naman siyempre ang judge magre-rely lang sa isang declaration. And if again, according to the provision of law, that it does not appear to be trustworthy, then the court will reject it. The next, declaration against interest. This is very interesting, okay? A declaration against interest is reliable and trustworthy as an exception because the mindset of the rule is that if it were not true, he would not have made that statement because it's a declaration against his interest. Why? Siyempre, natural sa tao. Ako magaling Ako mahusay Ako mayaman Yun ang nature ng tao. So the provision of the law as an exception knows, pag sinabi mo hindi siya, baka maaaring totoo. Because you would not have said that if it were not true. Yung property na tinitran ko. Property ng kapatid ko yan. The money in my bank account, that's the money of my brother who is an overseas Filipino worker. Okay? Yan po, ganun yun. So that's why it's given a certain level of reliability. Besides, the person who made the declaration is already dead or unavailable. Today, okay, nabago bang konsepto? Hindi. And what I've explained so far is declaration against proprietary interest, declaration against pecuniary interest. Ang ipinasok sa provision dito, which was taken from the case of People versus Toledo, a 1928 case, is what? Declaration against penal interest. Siyempre, yun naman nagdeklara kung wala naman na yun or unavailable. Hindi siya matatakot na makukulong. That's why this is taken with what? Should be taken with care. Okay, hindi basta lang tatanggapin. Kaya may standard na binigay ang batas. Why? the statement tending to expose the declarant, no, the person who is dead or unavailable to testify, that exposes him to criminal liability, can only be offered to exculpate the accused if it is what? With corroborating evidence. So if it's just a singular statement, oh, ako gumawa talaga yung krimen na yan eh, the person is dead or unavailable to testify, the court will not accept that. Because the requirement of the law is not only that he declares, and not only his purpose is to exculpate the accused from his liability, but there should be what? Corroborating evidence, circumstance, clearly indicating what? Trustworthiness. And at this point in time, I would want to highlight the word trustworthiness. And for students who are listening to me right now, those who are in third year or those who are in underclassmen, always remember that an exception to the hearsay rule is important, could be ascertained in the light of the trustworthiness and reliability. Okay, now let us now proceed to another exception. The next is an act or declaration as to pedigree. An act or declaration about pedigree. Now, bago ko sabihin, kasi makikita nyo, ang amendment lang dito, dalawa eh. Ano yun? Adoption. And the second one is that she is intimately related, associated, as to be likely to have accurate information as to his pedigree. So he should be intimately related to the family, associated with the family, as to give accurate information as to pedigree. Parang, hindi ko na iwanan yun doon. Parang, iba mag-isip, okay, parang gano'n. Hindi. Ganito yun. For us to have a good grasp or handle of this, we will have to understand how does the provision work. Okay, the person who made the declaration that he's related, for example, to Mr. X by birth or marriage, this is the original provision, is already dead. Yung nagdeklara, sabi niya, anak ko yan eh, si X eh. Or I'm related to him by birth or marriage. And that declaration is not given to that person. That declaration is given to another one who at some later time, because of lack of available evidence, will attest to my declaration during the time that I'm alive and during the time that I was still available. Kaya lang, hindi na ako available to testify, if you would recall. So here, he will testify. By its nature, it is hearsay. Sabi ko eh. Anak ko yun eh. Okay? That's how it works. And the witness did not be related to me. Now, let us look at this. Yun lang ang dinagdagan. Related to me, the declarant, by birth, by marriage, by adoption, and therefore that includes legal adoption, or in the absence of this birth, marriage, or adoption, or what? With this family, I am intimately associated as to give an accurate information as to pedigree. Yun ang amendment, and that's how it operates. Now, if you would note, I did not include in our outline yung family reputation or condition as to pedigree because it only amended one word, adoption. But unlike the previous provision, kindly take note, unlike the previous provision, that there is a declaration and there is a witness who received the declaration who will testify in court. Okay? In family reputation, the source of the information is unknown. It has been moving around the members of the family, may have been passed on from generation to generation. But it is reliable because it's a story, information moving around the family. And who will testify here? Here, who will testify on family reputation or provision as to pedigree? He should be a member of the family, as distinguished from the previous provision. Okay. Now, I hope that is clear. That's clear. Let us now proceed with common reputation. Okay. Let us now proceed with common reputation. I hope you're still with me. We still have a full hour. And ayoko lang kasing madalian. Baka mas maaga tayong matapos, pero ayoko lang yung paspasan for the benefit of some students who are taking time to listen. No? And I hope I'm able to help you in your understanding of the new provisions. And to this extent, I could tell you that around 95% to 97% we are trying to cover. Okay, now let us now look at common reputation. Now, common reputation, as we know, reputation is how people perceive you to be. That's reputation, as distinguished from character, who you really are. But your reputation could be bad, but that's not who you are in terms of your character. So reputation is how people perceive you to be. And now that is again an exception. The source of the information Okay, bumalik na ata ako, no? Ako'y pansamantalang nawala. I am, okay, sabi na. I was reminded that I was disconnected, but I think I'm back. I think I'm back. I hope I'm back. So I will just have to repeat about my statement of common reputation. The source of the information is not known. It has been moving around in the community. And based on the old rule, ano sabi doon? Of public or general interest for more than 30 years. Wala na po ito. Ito ang pinaltan. Of public or general interest. Because based on US authorities, because this was taken from federal rule on evidence, sabi nila, that's very hard to prove. There's a dearth of examples of this. So that of public and general interest for more than 30 years, which is actually ancient, has been replaced. It has been replaced by what? As to boundaries of customs affecting land in the community and the reputation as to events of general history important to the community. Now, why was it replaced with boundaries or customs affecting lands in the community? Because according to authorities, US authorities, is that the common reputation as to land, as to boundaries, okay, is what? Subject to scrutiny in the community. That was subject to scrutiny in the community. And it is what? Reliable because it was subject to scrutiny. And the purpose of this is there is really no likelihood that you will obtain some other evidence. So you rely on what? Common reputation. And as a final statement, hindi pa ako tapos ho dito ha. As a final statement, it represents, because it's subject to scrutiny of the community, it is subject to the consensus of the community. Let me give you an example. Yan, yung lupa na yan, yung tinatayo ng building na yan, dati yan yung train station ng PNR. Okay? Or itong bayan na to, dito, huling nagtumayo ang mga guerrilla bago labanan ng mga nilalabanan ng mga Hapon. Okay, doon sila huli naglaban. Sa Nueva Ecija, meron nun. Okay, general history important to the community and that's known, has been passed on from person to person. Kindly take note of that. Okay, now, and besides, if it is something that is settled, readily verifiable, naisulat na, that is subject of what? Judicial notice. Again, as to marriage, as to moral character, common reputation has not been changed. So I will not discuss that anymore. The next item is res gestae. Okay, res gestae. You recall what res gestae is. This is also an exception to the hearsay rule. There are two kinds. What are the two kinds? Those which are arising from a startling occurrence. We were startled. We were excited. And because of that, there was no room to reflect. There was no room to contemplate. And for that reason, there's no room to fabricate. Hindi ako pwedeng gumawa ng kwento. Kasi startled pa ako. That's the first kind. And the second one is equivocal act. But the equivocal act is given legal significance by the statement. There is a statement that gives legal significance to the equivocal act. Hindi natin pag-uusapan yan. Ang pag-uusapan natin is the res gestae of the first kind. Because the amendment is on that point. And based on the original provision, sabi niya, statements made while startling occurrence was taking place. While the startling occurrence was taking place, immediately prior, ito yung sabi, and subsequent. Yan ang provision ng batas. Pero dinagdagan sa amendment. Ito yun. Under the stress of excitement caused by the occurrence. I will repeat. Under the stress of excitement. It only highlights what I already mentioned to you. Because if you are under the stress of an excitement, you cannot fabricate. You cannot make up a story. For example, I went out of my house. Not my house. I went out of my classroom. Tatapos na yung klase ko. Let's say, alas 7 ng gabi. Nakita ko. There is a student hitting another student with a pipe, and I saw naduguan siya. So, and then police came, authorities of the school. But when I went home, I was just let's say walking distance from the school. Grabe yun. Siguro baka mamatay yung batang yun. That was my thinking. That was from a statement arising from a startling occurrence that I made. Kaya lang pag uwi ko, walang tao, wala asawa. Wala yung miss ko, wala yung mga anak ko. Gusto kong ikwento. Nakatulog ako, kumain ako. After 4-5 hours, ang dami ko na napanood sa TV. Tapos dumating sila, kwento ko. I am no longer under the stress of an excitement. Okay? Now, you tell me, sir, does it mean therefore that it should be immediately? No, because there are numerous jurisprudence in the Philippines that allows res gestae even after 2, 3, 4 hours, for as long as he is under that state of excitement and under stress, for as long as there is no room to fabricate and make up a story. Hindi ba? Pag nag-settle down na kayo, iba na kwento? Ganun yon. Yan ang pinoprotektahan ng batas. Okay, now, let us now proceed to the next exception. And this next exception will be very interesting for you. Kindly take note, no? Kindly take note. Itong records of regularly conducted business activity. Records of regularly conducted business activity. If you would recall, for those of you who have taken up evidence, maalala nyo, this is the entries in the regular course of business. Naalala nyo yan? Entries in the regular course of business. And why? Old rule muna tayo. Why is it reliable? Why is it trustworthy? Because the person is dead, unavailable to testify. Number 2, that the entry was made in the regular course of business at or near the time of the transaction. And number 4, in the performance of what? Of his professional responsibility. In the performance of his official function. Nung professional na yun. Kaya siya reliable. Pero yung provision na yun, medyo malabo. Tumitigil lang yun. And if not properly explained, the students will not understand that it is an exception to the hearsay rule, not because of the witness who will later testify, but because of the document and the circumstances of the entry. Kaya nagkakaproblema doon. But now, and this is why I'm very happy with the amendment. With the amendment, it practically covers any memorandum, report, record, data, compilation. Okay? Made by writing, typing, electronic, or optical, or other similar means. And kindly take note, na-retain pa rin, pero di nag-in-expand ng konti. At or near the time of what? Of the transmission or supply of information, which the person has no knowledge. So before, at or about, or at or near the time. At or near, okay, the time of or transmission or supply of information by which the person has knowledge. And kindly take note that the data, information, documents, memorandum that I'm referring to, compilation, was what? Made in the regular course or conduct of the business. Meaning, and such was the regular practice. So dito, ano na nawala? Dead or unavailable. Okay? Nawala na yon. Nawala na rin yung sinasabi na dapat in the performance of his function. Nawala na yon. Okay? Nawala. Oh, this sir, hindi na reliable. Wait. Okay? You will see that here, the memorandum, report, or data compilation, by whether electronic, optical, or other similar means, are shown by testimony by whom? The custodian. Or number 2, by qualified witnesses. Okay? Kindly take note, wala yan sa dating batas. Okay, sa dating rule, wala yan. It is a lot better. Why? Because now, maliwanag, custodian lang pwede na. Or someone who is qualified, maybe a substitute, maybe the assistant can testify. An assistant controller if it involves financial documents. Pero noon, actually noon, malilito ka under the old rule. And I've had instances wherein my opponent will object if my witness, if the person who prepared the documents I presented was not available. Sabi niya, no, Your Honor is not competent. He was not the one who prepared the document. I had such a case. 50 documents, lahat inobjekan. It was just good that it was overruled. Bakit? Ang thinking kasi ng abogado, dapat dalhin mo siya. But now it's fairly clear when you're talking of a memorandum, a compilation, a data, whether electronic, optical, recording, pwede. Basta at or near the time of the transmission of the information and under which the person has knowledge and in the regular course of business. Sino pwede mag-testify? Yung custodian or qualified witnesses. I hope that's clear. And for practitioners listening to me, this will be very helpful sa atin. Hindi na tayo masyadong mahirapan na every time, pag-authenticate pa lang, katakot-takot na objection, paliliguan tayo dyan. Okay, the next. Testimony, which should have been the last exception. Okay, dati itong last exception. Okay, pero meron nang last, ito yung second to last. This is the penultimate lamang sa ngayon, exception. Testimony or the deposition taken or given in another proceeding. Now, sir, do we have the same rule? Pareho pa rin. The same application, yes. Ang pinalawak lang, di ba, nakalagay doon, a person is dead, okay, witness is dead, deceased, or unable to testify, or unavailable to testify. That was the old rule. But now, the unavailable has been expanded. Kasi, pag sinabi bang, I am in a business meeting, unavailable ako. If I have a conflict of schedule, unavailable ako. No. Now, it's very clear when you talk of you're not available, you are outside of the Philippines. Or you cannot with due diligence be brought to court or be found in the Philippines or unavailable to testify. So dapat mapapakita with exercise of due diligence na talagang hindi siya pwede. Efforts have been made para hanapin mo siya. Hindi lang pwede, ay, conflict ako, nasa abroad lang ako. No. Okay? So now, they made it clearer. What do you mean by unavailable to testify? And this was taken from Rule, what? Rule 115, Rights of the Accused, Section 1, Subsection F. Okay? So pina-expand, niliwanag lamang ito. Now, so the same rules are, yes, a testimony, deposition given in another proceeding, if there was what? It involves the same subject matter, the same issue, and there was the most important thing, the most important phrase, an opportunity to cross-examine, even if there's no actual cross-examination, for as long as there's an opportunity to cross-examine. Yan. Dito na po tayo sa huli. Pero hindi pa ako tapos. Hindi pa ako tapos. Nandito lang tayo sa last exception ng hearsay rule. Ano yon? Residual exception. Nako. Alam niyo, aminin ko sa inyo, to students, nung una ko to, parang, ano ako, kasi I'm more of a conservative when it comes to the rules. Sabi ko, nako, kasi medyo liberal ang approach nito. And even the congressional intent of the US lawmakers, because we patterned this from a US rule, okay? From Rule 803 and 804 of the Federal Rule on Evidence. Kaya kailangan ko sabihin kasi bagong talaga ito eh. Para kung gusto niyo i-research, mas maintindihan ninyo. Okay? So, the intent, the congressional intent there was really to make it a catch-all exception. That's one. Though it's a catch-all exception, the intent was so that it will only be rarely used and only in exceptional circumstances, with conditions designed to make it only less accessible to practice, citing Lampert and Salisbury. Yun ho yan. Ganun yung intention nun. Now, to give us an idea of the root nitong residual exception in the US, let me give you the case of Dallas County versus Union of 1961. It all started with a newspaper account, a newspaper article that made mention of a fire that occurred in a certain place and that was given a certain level of trustworthiness. And because it wouldn't fall in any of the exceptions, sabi na, residual exception. Because sabi ng court, the exceptions in the US, they said the exception should not hamper the search for the truth. Okay? Kaya lang, sa panahon ngayon, ang daming fake news, medyo mahirap. Medyo mahirap. But again, it does not prevent us from using residual exception. But there's one thing I would want you to take note, to share with you. So sa sinabi mo, attorney, ibig sabihin, minsan lang gagamitin ito kung talagang hindi na maiiwasan. However, there are now two views evolving in the US. That is the strict view that I mentioned to you, and there is the more open view, wherein some states have now been adhering to. Now, kung magagamit siya, gamitin yan in the search for the truth. Okay? Now, I think this is what we have to expect from our judges. What is required is a careful, sensitive, and judicial examination of the offered evidence and the justifications for admitting the same. So, the burden, ang mahirap talaga sa mga judges din, malaki na yung binabalikat nila. Even sa civil procedure, malaki. Pagdating dito, mas malaki. So talagang pag pinasukan sila ng residual exception, they really have to use their judicial examination. But please take note of this. There is a procedure that is to be followed. So if I intend to use residual exception, I will have to give notice to the other party, adverse party. Ako ang proponent ko I will use residual exception. But I will have to raise that notice or put that notice to the other adverse party when? During pre-trial or in advance of a hearing. Okay? During pre-trial or in advance of the hearing to provide the adverse party para yung kalaban ko will have a fair opportunity to meet it. And it is my duty as the proponent to state my intention, the particulars of the same, the name and address of the declarant para alam. Ano ba? Sa kailan mo ba ito gagamitin? Ano ba yan? Ano yung purpose? No, the intention and the particulars, the name and address, so that the adverse party is well aware that I will use or avail of residual exception. I hope that that's helpful for us, no? The next is opinion rule. Opinion rule. And what about opinion rule? Class, itong opinion rule, Ang binago rito yung Section 52, Rule 130. Yung definition ng sino ang pwedeng magbigay ng opinion. Opinion of a witness on matters involving special knowledge, skill, expertise, training. At dinagdag doon ng education. Yun lang ang dinagdag. But the same, every expert will have to be qualified, because no expert can be presented in court unless he passes the qualification. Now, let me just discuss a little bit education, because the drafters were well aware that there are some expertise that would require education before they attain that expertise. Like, for example, doctors. They would have to finish their degree in medicine, okay, before they be presented as an expert. But education alone would not suffice. Their experience, their years of experience and training will help them be qualified as an expert witness. In fact, in one case decided by the court, it involved a dengue death. No? May namatay na bata sa isang public hospital dahil nga sa wrong diagnosis ng mga doktor. So dinimanda yung public hospital pati mga doktor. So kinwestiyon ngayon nung mga doktor sa hospital, sabi niya, hindi naman na expert yan eh. Pathologist yan eh. Sabi niya, he's not even a pediatrician. Bata kasi namatay. So sabi ng Supreme Court, well, although that is ideal, but the experience, special skill, knowledge, and experience on dengue cases, which run to almost, I think, 40 cases, that's what the Supreme Court said, will qualify the person as an expert, okay, or the doctor as an expert. Now, let us now proceed to character evidence. Ayan. Patapos na tayo ng Rule 130, character evidence. I'll walk you through. This will be my last discussion on Rule 130. Then I'll now move on to what? I will move on to Rule 131, burden of proof. Basta malampasan natin ang character at burden, hindi tayo masyadong mahaba. No? Yung presumption, I would like to discuss with you, but that is not long. Once we're done with that, we're more or less about to finish. But we have sufficient time, okay? Now, let us look at character evidence. If you will look at the original provision of character evidence, you will not find a prefatory paragraph. Wala kang makikita ron. Makikita mo ron, character evidence, ito na yon. Criminal, ang nakalagay ron, criminal, civil, witness. Yun ang nakalagay nun under the old rule. But now there is a prefatory paragraph that says a person's character cannot be presented as, is not admissible to establish what? To prove an action or even a particular occasion. Now, mahirap yan. Sabihin mo, sir, ang hirap naman ng language na yan. Magulo. Okay, ito lang yun. Character cannot be used as evidence to establish an offense, a crime, a cause of action, or a defense. Okay? Ganun yun. Why? Because it will confuse issues, unfair practice, or prejudice. If you are prosecuting a person on a criminal case, you can present his bad character. Masamang tao to, ganito. Prove the case, the facts and circumstances on how he committed the crime. That is first and foremost for the court to know. Okay? So yun lang yun. Wala masyadong binago. It's only a restatement of what we already know. Now, let us look at character evidence in criminal cases. Nabago ba yan? I won't take much of our time here. The answer is no. What was changed was the presentation. Nauna na ngayon yung offended party. Dati sa bottom ang offended party. Okay, offended party, the same rule, yes. That the offended party's good or bad character could be presented if it will what? Establish to a reasonable degree the probability or improbability of the offense charge. Pareho yun. Okay? Now, pareho pa rin ba, sir, na ang prosecution hindi pa pwede mag-present ng bad character na accused? Yes, except upon rebuttal. Yes. Sir, pareho pa rin ba na yung ang accused pwede mag-present ng good character if there is a character trait involved in the offense charge? Yes. Okay? Yes. Now, let us now proceed to what? Okay. This is just like transfer of provisions lang. Kindly take note that the provision on character of a witness there was just taken from Section 14, Rule 132. So that's just a transferred provision. Meaning, you could only present the good character of the witness once it is impeached. Kasi irrelevant naman ng good or bad character na isang testigo. The purpose of a witness testifying in court is only to attest to what? The matters that he has perceived. And perceiving can make known his perception to another. But the very moment his character is what? Impeached. Pwede mo nang pakita mabuting tao yan. Okay? Now, let us now proceed to proof of character evidence. Ito ang bago. Okay? Itong altogether bago. Proof of character evidence in civil and criminal. I will repeat, in civil and in criminal cases. Now, paano raw patutunayan? In all cases in which evidence of character or trait of character is admissible, what is the proof? And I would tell you, I'm very happy with this, and I think practitioners are happy because for the longest time, we've been asking, paano? Kasi we just rely on foreign authorities when it comes to this. But now it is enumerated. Number one, testimony as to reputation, as how people perceive you to be. He's a violent person. He's a dishonest person. Next, by testimony of what? In the form of opinion. I will repeat, it should be a phrase. In the form of an opinion, not an opinion. Because only an expert can give an opinion. In the form of an opinion. Okay, now, reputation, okay, kindly take note, according to authorities, is that reputation is more than an opinion in disguise. Totoo naman eh. Kasi yung kakausap ninyo, it becomes a reputation. So again, they say that an opinion is what? Reputation is more of an opinion in disguise. But what is the wording of the law? I will repeat so that we will not be confused. By testimony in the form of an opinion. But let me just make a side note. Okay, total na pag-usapan ng opinion. Bigyan ko ng side note. Siyempre, sinabi natin only an expert can give an opinion. But an ordinary witness can give an opinion. An ordinary witness can give an opinion on what? Mental sanity, identity, and handwriting. Now, let us now proceed. And on the last point on this proof of character evidence, on cross-examination, inquiry is allowed. So on cross-examination, so there is a reputation, right? There is it forms an opinion in the form of an opinion, which is a reputation also. On cross-examination, specific instances of conduct will be allowed. I will repeat, specific instances of conduct. Like for example, you said he's violent. Noong nakarang araw lang, nang hamon ng away yan. Namasok ng sari-sari store yan, sinira ho yun. That are what specific instances and could be presented on cross-examination. However, let me tell you this. According to you as authorities, it is not just like a free-for-all, okay? The cross-examination should only be limited to conduct pertinent to the truth or character. That's according to McCormick on evidence. To do sa pertinent lang. You cannot stray away and introduce extrinsic evidence. And finally, on proof of character evidence. Still on proof of character evidence, but unlike the first, in civil and criminal, okay, cases, here, when essential element of the charge. Meaning, when character is the essential element of charge, claim, or defense. So in that case, it's essential element of a crime, a charge, or a defense. Proof is by reputation? No. Proof is by specific instances. Like for example, in a civil case. Okay, I'll give you a civil case. A claim, sabi niya, he defrauded me. Okay, niloko ko niya, ito pinakita sa akin eh. Yun palang binenta sa akin, lahat peke. Puro substandard. Okay, that's fraud. And the character trait there is honesty. Okay, honesty. You could present specific instances. On this particular day, naloko rin to. Or in the past, entered into transaction with A, entered into transaction with B, ganun rin ang outcome. Okay, now let us now proceed to Rule 131. Are we still on schedule? Oh. Am I now connected? I think I'm connected. Okay. 2 minutes ago. Okay. A while ago, I was disconnected. Okay. I will end, don't worry, I will end at 5 o'clock. Okay, I will end at 5 o'clock. That is our schedule. Okay. Now, burden of proof. What is the in Rule 131? This is in Rule 131. Burden of proof definition is still the same. And kindly take note, it never shifts. So what was inserted by the framers there is long established rule that the burden of proof if in a prosecution of a criminal case, elements of the crime, you will have to prove it. It cannot shift. It remains with him. The burden of proof of the accused is his defenses. Burden of proof never shifts. It's based on the case of Bautista versus Sarmiento, a 1985 case. Now, how about the burden of evidence? This is an altogether new provision. Okay, an altogether new provision. Is it a good amendment? It's a very good amendment, because now with the burden of evidence, it shows that you will have to reach the prima facie case of the case of the case. You should be able to attain prima facie evidence of the case, whether to establish or to rebut it. Okay, whether to establish. Now, what is prima facie? That which sufficiently establishes a party's evidence to justify a favorable judgment. And unlike burden of proof, a burden of evidence shifts from one side to another. After I've presented prima facie evidence that establishes murder, lipat naman dito kung alibi. And thereafter, alibi yan. I do a rebuttal. Okay? And that is what? Another word for burden of evidence is burden of production or burden of going forward with evidence. Now, we are now on presumptions. Okay, we are now on presumptions. On presumptions, okay. No, I'm back now. Just a time check. I have 30 minutes. And we're okay. Okay. On presumptions, we have presumptions in civil actions. In civil actions, kindly take note that we apply here the bursting bubble. I just discussed burden of evidence. It's more or less the same as the burden of evidence. In presumptions, once the presumption arises, like presumption of regularity, he's a public officer, he was in the performance of his function, presumption of regularity. Once that is established, you could rebut it or you could meet it, okay, by other evidence to destroy. Hindi naman ka nagtatrabaho ng panahon na yan, so there's no presumption of regularity. And therefore, that is the bursting bubble that was taken from US jurisprudence, meaning you have to smoke out, okay, with counterproof the presumption. That was taken from Makovich versus Kansas City, a 1906 case. Now, another very interesting matter on presumption is inconsistent presumptions. And to be very brief, bago to, pag sinabi nila, when there are two inconsistent presumptions, that which is what? Which has a policy consideration will stand. Pag nagbungguan yon, laglag yung isa. That is not of the same policy consideration. For example, presumption of innocence and People versus Godoito, and presumption that Filipina will not institute an action, a Filipina will not institute an action for rape if it were not true. Which would prevail? Presumption of innocence. Okay? Kung nasa klase yan, may example pa ako sa inyo dapat. Pero ito na. Presumption in criminal cases. Okay? How about that is what? My discussion is inconsistent presumption, presumption in civil actions, and now presumption in criminal cases. Kindly take note. In criminal cases, you have to remember this. And for students, this is a bit medyo complicado, complex, but I know that you will understand. This was taken from the Federal Rule on Evidence 303, Rule 303. So that if you want to read it, B, Section 6. Okay? Here, this is a restatement that the presumption, the basis of guilt cannot just be a presumption. Okay? And let me read. If a presumed fact that establishes the guilt is an element of the offense charge or negates the defense, the existence of the basic fact must be proved beyond reasonable doubt. And the presumed fact follows from the basic fact beyond reasonable doubt. So this is purely a presumption in criminal cases. Therefore, there is a presumed fact that is the result of the basic fact. Okay, there is a basic fact that leads to the presumption. For example, let me give you this simple example of, let's say in a criminal case, a libel presumption of malice. While you will have to establish that and might prove that the act was malicious and it was indeed libelous, you will have to establish beyond reasonable doubt the basic fact na may publication yon about the statements therein that it was an imputation, a malicious imputation. You will have to establish that beyond reasonable doubt. Naturally, the result of it is a presumed fact will likewise have to be established beyond reasonable doubt, because according to authorities, McCormick on evidence, presumption to establish guilt or the element of the crime, and not any other evidence should be established clearly. Okay, not only must the presumed fact flow beyond reasonable doubt from basic facts, the court must find basic facts beyond reasonable doubt. Okay, now let's look at impeachment. We are now on Rule 132. Okay, Rule 132, Section 12. Sir, ano pa ba tayo? Okay pa tayo? We're on time. And I believe that we will be able to cover everything. Okay? Now, let us look at impeachment. Alam niyo, this is interesting because this is an impeachment of a prior conviction. Isang testigo, ini-impeach as to his prior conviction. Is that allowed by the present rule? Yes, that is allowed. This is the amendment is found in Section 12, but Section 11 tells you how to impeach. Contrary evidence, prior inconsistent statement, your general reputation for truth, honesty, or integrity is bad, and what? Prior conviction. You will find that in Section 11, the last line. You will also find that in Section 3 of Rule 132, subsection F, I think, or E, that tells you at the bottom, but the witness cannot refuse to answer about his prior conviction. So now this provision gives the parameters, the standards by which you are to present, to impeach on a prior conviction. Pwede mong gamitin yun, pwede mo siyang questionin if, number one, the crime, the prior conviction, was what? Was punishable by a penalty in excess of 1 year. Okay? Or if it involves a crime involving moral turpitude, the penalty is not important. Okay? Now, that was taken from the federal rule on evidence. Okay? Now, dito naman tayo sa cross-examination. Section 6 of Rule 132. Umatras ako ng konti. Gusto ko lang, kaya ko lang ito binanggit. Sasabihin nyo, sir, alam na namin yan. I would want you to share with you that a material phrase was dropped or a material line was dropped from the original provision. What was dropped? Ito. Any matter stated in the direct examination and connected therewith. For practitioners listening to me right now, you know for a fact, alam na alam ninyo yan for a fact, that for practitioners, alam natin yan, sasabihin natin, I'm conducting cross, the other party who presented the direct, oh, Your Honor, that was not covered by the direct examination. He cannot ask that on cross. Then I will say, Your Honor, I should be given sufficient fullness and freedom to test the truthfulness and accuracy of the statement and freedom from bias and interest and vice versa. Okay? Yun ang sasabihin ko. Now, sasabihin niya, oh, okay, I will allow you. But please, kindly take note, there has been a wrong notion of what is our rule on cross-examination. This is according to Justice Regalado. Ang sinusunod natin is the English rule. Kaya bumalik na tayo. The English rule means the wide open rule. You have the freedom to test the truthfulness and accuracy of the statement and freedom from bias and interest. Okay? Kasi noon parang, huy, not covered by direct, ha? Ngayon, open, clearly open, wide rule. Wide open rule. Now, let us now, I have already discussed evidence of good character, which was merely transferred to another provision. Now, exclusion of witnesses. Okay, exclusion of witnesses. What about exclusion of witnesses? Ganito yon. Siyempre, you don't want the witnesses of the other party to listen to what you're talking about. You don't want the witnesses to just get to listen and attune their statements with their co-witnesses, right? Lalo na sa kalaban mo. Okay, now, what does the provision say? The court motu proprio or upon motion, okay, may exclude witnesses so that they cannot hear the testimony of the witnesses. Pero ito may exception. A party to the case, whether civil, criminal with more reason, because he's the accused. He should be confronted with the evidence against him. Number two. Sir, paano yung mga corporation, juridical entities, their officers, and representatives, they're allowed to be present also in parity to that exception. The third, when his presence is essential to the presentation of the party's evidence. Like what? An agent who was the one who implemented the instructions of the principal. His presence is allowed. And there is a last. And according to authorities, this is just like an open window. Because if there should be future statutes, okay, that would allow it, then this is the window. Okay, this is the window. Let us now move on to the second paragraph of that provision of Section 15. Kung pinag-uusapan natin exclusion, ito naman, ay, layo-layo kayo. Mga testigo, separate. You have to be separated. Why? So that you cannot converse. Even directly, kayo, or through intermediaries. The purpose of the provision is in order not to thwart the provision of the witnesses not conversing. That's why it covers intermediaries. Let us now proceed to public documents. Okay. Ito material po ito. Okay. I am now in section 19. And for purposes of guidance, kindly take note that now there are 4 subsections. I will not discuss all the 4 because we don't have time, but I will discuss the amendment. The amendment now covers what? Documents that are considered public documents, okay, under treaties or conventions which are in force between the Philippines and the country of source. And here, this was brought about by the Apostille Convention, which was effective in the Philippines on May 14, 2019. Okay? Hindi ko na sasabihin kung kailan tayo nag-accede. May 14, 2019, by reason of the Apostille Convention. That is why it was inserted. And I think I have to discuss this. Yung Article 1 ng Convention, kasi yun ang kino-cover nitong documents referred to in the amendment. What are those? If you're interested, look at the article of the convention. Apostille, number 1, documents emanating from courts or tribunals, including public prosecutors, clerks, or process servers. Next, administrative documents, notarial acts, number 3, and the next, official certificates signed by persons in their private capacity. So ito yung kino-cover nung ano na yun, nung kinds of documents. And an example is the Apostille Convention, where the Philippines is a party to the convention, or where the source of the document is likewise a party to the convention. Now, let us look at this. How to prove, okay? Now, how to prove the amendment, section 24 remains intact, the first paragraph. Kaya lang dinagdagan po ng ilang paragraph. Now, when you're talking of act of sovereign authority, which is the first kind of public document, you will have to prove it by 1, very simple, by publication in a newspaper of general circulation, or UP Law Center publication, number 2, or a certified true copy. Ito na hong susunod ito ang amendment. And this is how to prove the insertion, yung amendment na pinag-usapan natin, yung by conventions, okay, or treaties, which the Philippines is a party. Now, if the document is originate or is kept in a foreign country to which it is a party to a treaty or a convention, and the Philippines is also a party to the same, what will be presented? The certificate that is required by the treaty or convention in that form prescribed by the treaty or convention. So kung apostille yan, ang tawag doon, allonge. And there will be a title in French, title apostille. Okay, the next. What if the source, okay, or the document is in the custody of a foreign country which is not a party to a treaty or a convention? Though the Philippines may be a party, but the source is not a party to the convention. We follow what we have been using before. And what is that? Consularized document. That which is certified and authenticated by the Secretary of the Embassy, Consul, Vice Consul, okay, or consular agent. Ganun lang yon. Now, kindly take note that any document today that is presented in court that comes with a certificate, okay, requires no proof, because it is prima facie evidence of its due execution and genuineness. Okay, but there are times that the treaty may have removed the formality, then no formality will be required. Now, let us now look at objection to offer. Naku, we have time. Okay, we have 16 minutes. We have just a few more. Siguro mga 5 points and then we're done. Objection to offer or lack of offer of testimonial evidence. Let's look at this. Siyempre, alam natin, if it's an offer, objection to offer of evidence, sa ngayon, today, it should be oral. Okay? Because in the past, before the amendment, the offer can be made, objection could be made in writing. So ngayon, it should always be oral. Now, some practitioners listening and would tell me, paano kung saan katutak naman yung dokumento? Well, we will have to leave that to the discretion of the judge. But what the law says now, if you have to object to a formal offer of evidence or exhibit, the same, you will have to offer it exhibit A, purpose, then the other party will object. Or you will have a rundown and you will object. And then the court will have to resolve. Now, how about objection to testimony? Because as you know, the offer of testimonial evidence is before the witness testifies. Your Honor, the purpose of presenting the witness are the following, okay? Or to establish the following. Now, the very moment it becomes apparent that there is no offer of testimonial evidence, you will have to object. Okay? Sir, is there waiver? May jurisprudence po tayo dyan. But this requirement of immediate objection when it comes to offer of testimonial evidence is in the case of Catuira versus Court of Appeals, a 1994 case. And as I mentioned, sir, papaano? Hindi niya nakalimutan. Lahat nakalimot. Nag-cross-examine na. There was no offer of testimonial evidence. We have jurisprudence on that point. And it was allowed by the Supreme Court. Okay? Now, objection to a question, there was no change. Okay? Objection to a question, no change. The duty of the judge, if there's an objection to a question, to rule, whether to overrule or to sustain. Ito lang idadagdag ko, added knowledge sa mga estudyante. If there are multiple objections, this is not an amendment, still the rule. If there are multiple grounds for an objection, it is the duty of the judge to give the reason for the objection. Objection, Your Honor, compound and vague. He will have to give the reason for his ruling. Okay. The next is striking out of an answer. Alam nyo, walang nag-graduate ng law school na hindi ito natutunan. May iba nagpa-practice court, may iba nagmo-moot court, and we have practitioners now and maybe some judges. Laging nangyayari po ito sa husgado, nakikita natin. When there is a question striking out of an answer, this is section 39 of Rule 132. Ano yun? Bago pa ako I was supposed to object. It was an objectionable question. But the witness was so quick, he answered the question. I will move to strike out that answer. Second, the question is not objectionable, but the response is not what? The answer is not responsive. Your Honor, my question is his duties as a president. He was telling me about his functions as a controller. That is what I will move to. I will move to what? To strike that out. The next is, if the witness makes a narration, abay nagkwento na, isa lang tanong, haba ng kwento, I will move to strike out, Your Honor. Or, where a witness is a type of witness who wants to volunteer answers every now and then, not a narration, and there being no question, you could move to strike it out. Okay? You could move to strike it out. Now, and finally, this will be our last slide. Okay? Weight of expert. No? Just in time. Weight of expert witness opinion. Ito yung maganda. For those of you who have been constantly or repeatedly asking, kahit mga estudyante ko tatanungin, sir, paano bang weight ng evidence na binibigay? What's the weight of evidence given to an expert opinion? In the past, I will tell them that is within the sound discretion of the court. That's within the sound judgment of the court. And it's good that we have it now. And it says the court has wide latitude of discretion in determining the weight given to such an opinion. It is the court's judicial determination. And according to the case of Dobert versus Merrill, okay, in-enumerate ito mga factors na ito. Ano yun? There should be sufficient facts or data. And the opinion should be based on what? Reliable principles and methods. And number 3, and the same was applied, okay? The witness applied the principles and methods reliably to the facts, meaning there's an application of the principles and methods to the facts. And 4, other factors as the court may deem what? Helpful. Now, in the case of Dobert, this is very helpful, no? This will guide us, the declaration of the court. It says, considerable leeway in the matter and listing of particular factors was meant, the listing was meant to be what? Helpful and not definitive. So we are not limited to this. It is the listing that I mentioned to you, and now part of the rule in Rule 133 is what? Should only be helpful, but not definitive. And finally, minor provisions that I hope will add to your knowledge ng mga bata, no, na nakikinig sa akin. There are minor amendment in Rule 133, Section 4. Hindi ba alam nyo circumstantial evidence that there should be more than one circumstance, and the circumstance taken together should be established and proven beyond reasonable doubt. Di ba? Ganun yun. And there is a line that an inference cannot be based on another inference. Hindi pa pwede. Circumstantial na lang. Ang basihan pa circumstantial. How can that be reliable evidence? That's the case of People versus Austria, which says conviction should be based on strong, clear, and compelling evidence. And finally, I will discuss this together. The provision, atas ako ng konti, is Rule 130, Section 31 and 32. This is admission by a third party. As a rule, a third party cannot make an admission for me. I can make a declaration, admission of a conduct, my conduct or admission, but not for another person. But there are exceptions. Exception of a co-partner or an agent. But kindly take note, may maliit na amendment doon. Because under that, for the admission of the third party to apply, it should be within the scope of the authority, while the partnership or the agency was in existence and the relationship was established other than by the admission. There was an assertion of what? Authorized after agent, authorized by the party to make a statement concerning the subject. This is only a reiteration to make it very clear that the person should have acted within his authority. Okay, that's why there is now the word authorized. And finally, another exception to the third party admission, okay, is what? In conspiracy, the insertion of the word furtherance, okay? Formerly saying relating to conspiracy, but now is in furtherance of. This is to show what? Motivating the notion of conspiracy. This is to draw our attention that it should be upon the conspiracy. So I think I have covered what we have covered. We still have, I think, 7 minutes. Thank you very much for your time. And I hope that the discussion has been very fruitful for everyone. And to some extent, I hope that I was able to help the students. Please continue to study, and read. If there are some things that are not clear to you, please try to research and to check it out. For practitioners, I hope that these are just some guideposts and highlights in your further study of law. And I know that with your experience, you will have greater insights. Thank you very much.